स्टे ही नहीं पर
ना एबी फाइल कर चले
देखिए
just type of anticipatory bail also one is
Transfer application. No pay is there, madam. Since it is a upper notice matter is not legal.
Pardon to make a mention, my lord. Second appeal of the
गोटे
Modification.
ନାଇଁ ନାଇଁ ଗୋଟେ ଯୋଉଟା ଆପଣଙ୍କ ହିସାବରେ ଯୋଉଟା 3ଟା ତା ଭିତରେ ଅଛି
No, modification.
ନାଇଁ ନାଇଁ ମୋଡିଫିକେସନ ହେଲେ କଣ ଅଛି
pardon to make a mention, my lord. Second appeal of the year 2016 filed a petition for substitution, my lord.
ଦିଅନ୍ତୁ
Pardon to mention, my lord, one Assam matter. I have provisionally selected since 2017.
ଦିଅନ୍ତୁ
Everything, my lord, the pleading is complete, my lord.
ଦିଅନ୍ତୁ ଦେଖିବା
transfer
we
application
try to get it listed as early as possible if possible before vacation
transfer application your worship fresh matter
Don't.
beg your pardon the transfer petition one more
no one
I have pardon to mention, my lord, WPC number 25094 of 2020.
कौन
An appointment order has issued, but petition was not allowed join. The matter related to Anganwadi worker.
केवे का matter
Matter 2020, year of 2022.
2022
Along with the WPC number 8807.
what is urgency nothing no urgency yes
Urgent matter. Transfer matter, your lordship.
what is the urgency
Stress matter.
fresh matter it will come on in its own course fresh matter would serially sorry hey fresh matter would serially it should come in serial to tell the DR you serially tak banibo yes
mentioned before here, your lordship.
Well, this is the matter that the lordship just recently delivered the judgment that the previous case. There are 13 matters. This 13 matters. 2013 is pending. Similarly, lordship
2013 matters
हाँ.
Mr. Acharya I am not bound by my own order I'll have to go through I'll have to read I'll have to see never covered matter a court hobo nahi
এই যে জজমেন্ট এবে previous case
এটা সে জজমেন্ট ভুল হইতে পারে সাবসিকুয়েন্টলি তাকে পড়লা পরে রিকল করে দেই পারে
আগে
so you have to argue there's no thing is covered in this court I will make it very clear sir I will go through the pleadings I'll go through the facts if it is covered then I will cover it
yes
lordship
I think I'm interested only in the number of disposal
না সেটা তো মোবাইল সেটা
no
সেটা
No. whoever might do it but I am गोटा कवर मैटर को देखि 600 डिस्पोज ऑफ करी कि मो नाटा पढेबी कोन मिलियो मोर सुतरा yes अपन दियो सबोडा दियो if they are connected we'll see
my lordship
my
lord one bail application
so get these matters listed आना तुसी जोड़ा तीन ताता को देखियो तो फाइल बार करियो देखिबा we'll get them listed if it's possible then before vacation
Lord, my senior Mr. Suryakant Deva, this father died, my lord. Item 16 and 28 prepare for next.
all right just make a mention when it reaches all right yes
my lord just praying for my listing of this bail application my lord has directed for its listing on the 29th but it has not been listed I had mentioned and had filed the mention memo also
yes it is because it is to come in the weekly list but since I'm also taking up second appeals in addition to all the matters so 2 days are devoted entirely for second appeals that is why there has been some we'll see give a memo we'll see please file a memo we'll see yes dekhido quote 29th re hitla if it was directed to be listed on 29th it will come in the weekly list it will come in the week
I'm obliged lords deeply obliged
yes
supplementary list item number 1 trace admission
May I please, your lordship? Paper transfer of GR case number 16 and 23 from the court of JMFC Polosara district Ganjam to the court of STGM Bolangir, my lord. And
who are you
in-laws.
Why do you want it to be transferred
My lord, kindly see page 4, para 7, my lord.
page 4 para 7 yes as among the also something from spinal cord problem with arthritis and also not able to stand for the lady is from Polsora
My lord.
it will be very difficult for the lady to travel from Polsora to I think there are
at Bolangir, my lord. Bolangir rochi. Bolangir rochi.
Kuti apna averment kain
My lord.
where is the averment that she is residing in Bolangir if she is residing in Bolangir why will she file a case at Polsora, interior part of Ganjam. Though a very developed place, but it is still interior. Why will she file a case at Balangir?
So 300 kilometers distance.
The lady will be put to trouble. The lady will be seriously prejudiced. So the convenience of the lady has to be seen. But let us do one thing. Let us obtain the learned JMFC Polsora. See, depending on it,
Malo.
learned JMFC Polsora is directed to inform this court whether VC facilities are available, whether facilities are available for parties to appear virtually. This order will be communicated to the court below. Forthwith, the report of the court below should reach this court by by 9th of May. No, by 6th of May. List this matter on 9th of May. No, 7th, 6th, 7th कर दियो. List this matter on 9th of May. 9th May. So this order be communicated to the court below forthwith by email. So the report of the court below should reach this court by report of this court below should reach this court by 7th May through email. All right, then we'll see. If VC facilities are available, it need not be transferred. Yes.
Number 2. Maybe.
Apne application. No, apne
Maybe. Petitioner to wife, my lord,
yes,
filed this application to transfer the divorce proceeding filed by the husband, my lord, from family code Puri to Khordha, my lord.
why?
My lord, other proceedings are pending in before the law.
All right, take notice. Issue notice to the opposite party by speed post, fixing a short returnable date. Requisites be filed by Monday. Kali working day. Kali the working day. So you can file. Working means the court working day. Right?
Sir.
Huh? Requisites be filed by tomorrow. List this case on 17th May. You filed any IA?
Yes, my lord. 103 of 2000.
In the meantime, if any application is moved on behalf of the petitioner in the court below, seeking adjournment, the same shall be considered, having due regard to the date fixed for hearing of this case.
Item number 3.
May I please? I have filed a matrimonial case before the sub-judge Kamakhenagar for nullity of my marriage. As because the girl is below 18 at the time of marriage. Subsequently, the matter is posted for hearing. And in the previous date, the opposite party and parents in the court premises itself accused me, slapped me, chappal lege marla, gote premises bhitar marla. I have filed an application to that effect before the court below. Before the court below said, it's a private matter, you can approach the authority. ମୁଁ ସେଇଠିକି ଯିବି ସେ ଯଦି ପ୍ରତି ଥର ମତେ ଏମିତି ଆବ୍ୟୁଜ କରିବ ଚପଲରେ ମାରିବ ଏଣ୍ଟାର କୋର୍ଟ ମୁଁ କହିଲି ବି ସିସିଟିଭି ବି ଦେଖନ୍ତୁ the London trial court had verified the CCTV. Neither have passed order to that effect that the opposite party and parents are undertaking though kichi kaleni kebal the order is at annexure 7 minor.
Annexure 7, yes. What is this order?
Well, second order. First order preclude kale, second order. This order arises out of the petition dated.
No, your allegation, you are alleging that you were abused and
my lord.
You were abused inside the court premises.
My lord. My petition is at annexure. Annexure 6, the order is annexure 7 page 36, the second order, my lord. This order
Why
arises.
didn't you file an FIR?
I have filed an FIR.
Then it's all right. You
But
should file
thing
an
is that, again, ସେଇଠିକାର locality, ତାଙ୍କ ଘର
All right.
ଯିବି, ମୁଁ କେବଳ ଗୋଟେ fair and, my lord, that is why I have.
Issue notice to the opposite parties by speed post, fixing a short returnable date. Requisites be filed by tomorrow.
Right.
List this matter on Kebe. Further proceedings in MAT case number 22 of 2022, pending in the Court of Learned Senior Civil Judge Kamakhanagar, shall remain stayed till the next date. Since you have already lodged an FIR, I need not pass any order on that.
My lord, thing is that tomorrow is the posting.
I've stayed it.
Can I get a certified copy in 2 days?
You will get it.
My lord, that may be reflected in
Urgent
the.
copy be granted in course of the day.
Obliged.
This is similar to Dhananjay Chand case, my lord. I have supplied the corrected copy.
Yes. Same. All right. Same.
Some small prayer error. In the prayer portion, my lord, 2018 age instead of 2008. I'll correct it.
Next, learned counsel for the petition is permitted to correct the typographical error in the prayer portion of the writ application in court.
Obliged.
Item number 5.
Last time is on lordship has directed to get the guideline matter to the state council with regard to appointment and disengagement of ASHA Karmi matter. The lordship has directed the state council to get the guideline
Guideline for?
with regard to appointment of ASHA Karmi matter.
Yes.
My lord, I have downloaded the guidelines, my lord. But with respect to the disciplinary action, if it is required, what will the modality and other things, my lord? But it is actually under the NRHM. NRHM is not a party. Mr. Bibhu Tripathi, my lord, and SJ, my lord, he is also actually the counsel, special counsel for this. I had contacted him, my lord. I only require up to Monday, my lord. I can collect all the documents.
All right. Yes, Mr. Math.
Monday.
Monday, how about? Friday. Friday to Arthur Chutti Ochi?
Chutti.
So we'll take it up on Thursday.
Thursday.
Thursday. Sri S.N. Patnaik, learned AGA, requests for a short adjournment as he has not been able to obtain the necessary instructions. List this matter on 9th May.
Item number 6.
Clear.
My lord, item number 6 and 8 covers common question of law and covers the same principle as both have to be heard together, taken together. Your lordship, remember the issue in this case is.
So I'll also open the item 8.
My lord.
Item 8 we will keep it.
Along with that,
All right. So this matter 16151 of 2019.
yes, 16151 of 2019.
Yes.
The issue is very simple, my lord, as to whether 5 years it will be deducted for that career advancement scheme payment or for the employees belonging to the aided educational institution who were selected and appointed by the governing body, and that has been given to the persons who are selected by the state selection board, appointed by the governing body. My lord, in order to counter your lordship can have a look to the
counter file in the other writ application.
Additional counter affidavit filed by them.
No, in that other writ application or in this writ?
Other writ application, because that has clarified everything.
Additional.
That was filed on 27th. Your lordship will kindly get it at.
No, they have
filed.
There is no additional counter.
Yes, additional counter, man. Because I will just press that, thereafter I will come to the.
No, additional counter to nahi.
Sir, actually, additional counter. Also, is additional counter. Vijayanandare, sir.
No, sir, ଦେଇଛନ୍ତି ଆପଣ ଲାଟେଷ୍ଟ ଦେଇଛନ୍ତି ଏଥିରେ ବିଜୁ ଦୟାନନ୍ଦରେ ଦେଇଛନ୍ତି
ସେଥିରେ ଆପଣ explain କରିଛନ୍ତି why you have not given. Same thing. 24 ରେ ଯୋଉ ଦେଇଛନ୍ତି। ଆଜ୍ଞା, that is on 20 and that was 6th of April 2024. 5897 of 2004, because the law covering both the fields are both the cases are one.
When was it filed? 6/4/2024. It's not.
6/4/2024.
It is simply an affidavit. It doesn't say additional affidavit.
My lord, they say because
Counter affidavit. They say it is counter affidavit.
Order, unless they filed an affidavit, they should have added it as additional counter.
But they say counter affidavit.
If they say counter affidavit, you can come to the question raised by my lord was on the other day, that when you have extended this benefit in favor of the employees who are appointed by the governing body, having been sponsored by the state selection board, by deducting 5 years, why you have not extended this benefit to the employees of the aided institutions who are recruited, who are selected and appointed by the management? You also can come to paragraph 8, because that reply was not there in this case. That's your lordship, while hearing that, categorically wanted to know.
Yes.
I'm sorry, your lordship may come to paragraph, running page 7, paragraph 12. The non-government aided colleges, the lecturers are selected in 3 ways: by state selection board, SSB, by the then DPI, now direct DHE, and by governing body.
Just for my understanding, nowadays there is no appointment through the DHE. Is there any?
Nowadays that is not there.
Only 2, SSB or management?
Yes, fine. SSB very rarely sits, but mostly governing. My lord, this is
SSB very recently they have engaged more than 1,000 persons.
In recent election.
One of my close relations was an applicant. I know.
Like, now we are in a stage, those who have been appointed prior to the Amendment Act came into force.
Yes. No, I just wanted to know.
Yes, but I 100% agree that nowadays, some occasions, some persons are selected as state selection board. But the question comes, my lord.
Advertisement.
The question comes, they are all selected by the different sources, appointed by the governing body. That they have admitted here.
Appointment authority is the governing body.
Appointing selection authority may be X, Y, Z, it is the material. The appointing authority is the governing body. After being appointed, they are approved by the government. On behalf of the government, director, they gives approval. And after they got approval from the director, they get the gratuity. Till they get the approval, they were being paid by the management. As your lordship put a pertinent question, why have to that? That is why they wanted to explain in paragraph 12.
Yes.
State selection board is a statutory body constituted by state government for selection of teachers in non-government aided colleges. It follows due procedure and ORD Act when selecting lecturers. The intending candidates applying in response to an advertisement would know that SSB is a statutory body, unlike the other 2 forms by which a person may have been engaged. Therefore, it is not possible to assume any equality between DPI appointed. There is no appointment by the DPI, that is selected. They wrongly they have given appointed, selected candidates, and GB selected candidates on the one side and SSB selected candidates on the other. Thus, there is no irregularity in clarifying them. There is distinction. Probably they wanted to classify, they have made it clarify. Anyway, whatever they have written, clarifying that there is distinction between the lecturer selected by the governing body and the lecturer sponsored by the state selection board, for which deduction of 5 years is a mandatory condition kept for consideration of placement under CAS in respect of former group of lecturers under which the present petition falls. My lords, here I fail to understand. I was searching hours together where from they got this mandatory condition of 5 years. if mandatory condition they mean that has been provided in 1989 circular or 89 circular, then it is applicable to everybody, sir. Those were appointed by those who are selected by the state selection board, appointed by the governing body. Those who are sponsored by the director, appointed by the governing body, and selected by the governing body, appointed by the governing body. The law, on the other hand, after that I will come to my lords at the cost of repressing my own memory before my lords. There is no distinction in any of the resolutions passed by the state government. Rather, on the contrary, these federal courts settle the law. They are all to be equally situated, and there is no distinction between a person selected and appointed by the governing body by the state selection board, person selected by the director appointed by the governing body, or the person selected by the governing body appointed by the governing body. This distinction they have made, my lords, is an artificial classification between the one class of people. That has been number of times reprimanded by my lords. You cannot make a class between a class. If the law requires that the employees belonging to the aided institution approved by the competent authority are entitled to be covered under a particular process, you cannot subdivide by that. And giving your lordship then kindly see, the state select, that is the 5 years is mandatory. Then paragraph 13, the government in higher education department by office order number 18623/HE dated 18/7/2013 have decided not to deduct 5 years of the service of those who are sponsored by the Service Selection Board, SSB, and appointed against approved post in different non-government colleges of the state. A photocopy of order B/1. My lords, I draw my lord's attention to annexure B/1. Much have been said about the government decision. Can lordship have a look to annexure B/1 at page 18? This is a letter written by one G.K. Dhal, Principal Secretary of Government. This is neither the issued approved by the cabinet, nor issued under the signature, under the approval of the governor. This is a letter written by the secretary, like I will not say, but because your lordship have the experience. Can this be treated as the decision of the government, my lord? Let us read it, my lords. What Mr. Dhal has said. As per amendment of Orissa Education Act 1998, issued by SO, etc., which has been published in Orissa Gazette, 5 years were deducted from the initial joining period of lecturers while calculating their length of service for placement on lecturer SS and readers under CAS in respect of the teaching and non-teaching, non-government aided colleges for the state. Representation was received from non-deduction of such 5 years.
No, from the United Teacher. Pratham line is
United Teachers and Employees Association Orissa Bhubaneswar for non-deduction of service 5 years from the service in respect of SSB candidates, sponsored candidates, as they were appointed against approved post at par with the government college employees. Here my lord may have a project. At par with the government is Rule 9 of the recruitment of Rule 1974. If you are adopting in par with the government servant, Rule 9 is a statutory rule. You cannot deprive some persons from the, while applying Rule 9, giving them the benefit and depriving other persons from getting the same benefit. You have taken a conscious view. You have taken a conscious view that by representation of X, Y, Z material, my lord. And you are relying on the appointed against the approved post of which government college lecturers. You are extending the same benefit to a particular group of persons appointed belonging to one cadre, one category, my lords, I would say. Then what you say? After careful consideration, the government have been pleased. I fail to understand where the government is, this letter, to decide to not to deduct 5 years of service of those who were sponsored by the Service Selection Board and appointed against the approved post in different non-government aided colleges of the state. Once the person is approved by the competent authority, by the state government, be appointed by the state selection, sponsored by the state selection board, and sponsored by the director, or selected by the governing body, they all come to a one category. And therefore, my lord, this has come by him. Then your lordship can come. Why is such a thing arose? What I have understood from that annexure, my lord. Now your lordship can come to the resolution of 1989, that is A by 1.
Yes.
They come. If you are strictly following this, according to this, 8 years each will be deducted. Very good. Deduct from everybody. Those who continue under one category. Then, my lord, because I will be pressing one paragraph, then I'll come to the other circulars. They say 7C, 4, A and B, because of financial crunch of the state government, whatever they like. Can your lordship have a look to clause 5 at running page 16? While introducing this scheme, my lord, state government consciously has taken into matter clause 5, central assistance at the rate of 80% of the additional expenditure involved in the introduction of the revised scale of all college teachers will be available in respect of the post which were in existence on 1st January 1986. Your lordship is to see whether the post against which you have been continuing was available on 1st January 1986 or not. We are all approved, my lord, prior to 1st January 1986. Once we, this and the central assistance having been extended by the, as decided by the state government to the 80%, my lord. The plea that if they take that the financial burden is on the state is just a misnomer, my lord. Just they want to play hide and seek game with the court. And whenever this letter was issued, my lord, this was issued on 18/7/2013. When your lordships have categorically decided there cannot be distinction between the government lecturers and that too of the aided lecturers. Lecturers were selection board lecturers and management lecturers, and that has been upheld by the Honorable Apex Court as late as 2002, my lord. Once the law has been established, you wanted to write a letter making a discrimination between the parties within themselves, allowing some benefit to the lecturers, those who are continuing in the having been sponsored by the state selection board, on the plea that they cannot be discriminated against section rule 9 of the recruitment rule 1974. At this juncture, my lord, let me place rule 9 of the 74 rules.
I don't think necessary.
Your lordship must have seen number of times. There is no need of writing, placing it.
At par with government employees?
Yes, my lord. Everything, leave, salary, pension, all, they must get the same amount and same process. Now your lordship can come to the Mr. What your lords, here in the first case, my lords, I am challenging the decision given by the secretary, which he was to take decision as directed by this honorable court. Because your lordship has used the word consider, he wanted to express such a decision. Your lordship can have a look to at the cost of repetition. He has taken the benefit of the amendment of section 7C 4A. And he has also quoted that in his order. Prior to that, let us have a look what this honorable court directed to the secretary to do.
I think that point is taken, sir. You have argued extensively on this particular.
Yes, my lord. And what I wanted to, the state represented through their own counsel,
According to their
they
concern.
take a different stand now because they considered Mr. S. Mishra, learned additional government advocate, appearing for the state opposite parties, states that since issues involved in the writ petition has already been decided by this court, in common judgment dated 13/12/1996, rendered in OJC number 491/2 of 1993, nothing remains to be adjudicated in the present writ petition. Therefore, this court may dispose of the matter, directing opposite parties 1 and 2 to consider the claim of the petitioner in the light of the common judgment mentioned supra. Once you accept, you concede, and the matter was remitted at your concession as per the order, even if you would not have considered, the law applies in my favor, my lord. Your lordship would have directed that, yes, decide the matter on this light. And now they come forward, my lord, your lordship have quoted operative portion, next page 25.
Yes.
Very categorically, your lordship have quoted the order so that that will be taken, at least the appellate authority, the secretary will look after that. Now, my lords, the directive may kindly be seen, though at the cost of repetition. In the above view of the matter, applying the ratio decided by this court in the above common judgment dated 13/12/1996, this court directs the opposite parties number 1 and 2 to consider and decide the claim of the petitioner in terms of the said judgment by affording opportunity, etc. He could not, my lords, he was within the rail line. He was to travel within that. He could not have gone this way, that way. The moment he will go this way, he is to meet an accident, and he has met an accident here. That is why I'm before my lord. Your lordship can have a look to the division bench, Justice Patra and Justice Datta, who has, I have placed it. I don't want to waste my lord's time because that's a
That point is taken, fully taken.
Yes, my lord. Now the question comes.
No, the matter was completely heard. Whatever sir, you have said has already been taken note of. The only thing that came to my mind is about that amendment being made retrospectively applicable.
Yes, my lord.
And you have also sufficiently explained now.
Now, my lords. Your lordship can have a look. I submitted on the other day that in order to circumvent the order passed by the Solo Court and affirmed by the Appeals Court, this amendment has been caused. Why I said so, my lord? Can we look to the objects and reasons
So
of the...
done to circumvent this court's order?
Exactly, my lord. And the objects and reason of the amendment is completely different, my lord, the way the amendment has been. Since I have not challenged the amendment, I cannot say so. But the objects and reasons for the amendment will show nothing has been said about this. Even if, my lords, let us read the amendment for a moment. That is prospective in nature. Because all have been done prior to that could not have been reopened by your amendment.
No, they have made it retrospectively applicable, and as I was inquiring on the last occasion, surprisingly it has not been challenged. The virus has not been challenged, that amendment.
It is not required to be challenged, my lord. Because we are covered directly under the principle.
No, that's all. That's all. That is, so far as this case is concerned, I understand. But ordinarily that amendment should have been challenged.
Ordinarily, those who have been appointed after 1998, because amendment came in the year 1998, ought to have, they would have challenged.
Somehow it has not been done.
It will be, my lord. The time is not passed because now they are going the way they are going on.
No, another matter, and I think Mr. Bimbisar Das was also arguing that matter. I told him to find out, and he also said that it has not been challenged.
This, my information, my lord, though it has been challenged, it is not yet decided. Some challenge, but I cannot make any reliance on that because, my lord, I am covered prior to that.
You were referring to that circular which says that all the employees of the unaided, private aided institutions. So it covers a whole.
Yes, madam. They cannot make a distinction, a separation. And your lordship, I have given a collateral bench judgment on that day. I don't know whether if you lordship or can
Judgment.
That was in the case of Sanjeev Kumar Mahanti.
It is here. It has been scanned also.
Yes.
So Justice Satpathi's order.
Justice Satpathi's judgment, where he has made a distinction. You cannot make by taking the plea of 7C, you cannot make a distinction between appointees of appointees sponsored by the State Selection Board and appointees made by selected by the state by the managing governing body itself. Because that has not been the intention of the, even if my lords, for my satisfaction, my lord, let me place for a moment the amendment itself, which they have very much relying on.
Yes.
Section 7C of the Orissa Education Act 1969, herein, etc. After subsection 4, the following subsection shall be inserted. The grantee be borne by the state government on account of placement of teachers in any aided education institution receiving University Grants Commission scale of pay under the career advancement scheme shall be limited to the extent as may be admissible by computing the period of service rendered by them against an approved post with effect from the date of completion of 5 years of service against such approved post, provided that nothing in this subsection shall be construed as to the seniority of any other, nothing, anything, etc., my lord. Then what they wanted, this, according to me, my lord, this was meant for the persons who are eligible or entitled to be eligible after January 1986. At this juncture, I had given a chart which was also before the secretary, the appellate authority.
Where is it?
At rolling page 50.
Yes.
We are all extending the benefit, my lords. The question that you are lacking any difficulty or you are not approved, we are all approved staffs. We have been receiving the salary. But the question is because 5 years and adding, we are deprived of getting our usual salary, which others are getting. Others means, my lords, the persons who are sponsored by the State Selection Board. I have given entirely the list of persons to so far till 2016. Though your lordship will kindly from annexure from page that was
yes, I've got it, page 50.
From page 52 onwards.
Yes.
Once you say that we are not entitled and others those are sponsored by the State Selection Board are getting, the only crux is they are sponsored by the State Selection Board. Whereas neither in the Act nor in the amended Act, any provision is there that those are sponsored by the State Selection Board, such a distinction can be made. Once you have made a relaxation for them, taking the plea of Rule 9 of the Recruitment Rule 1974, how can you make a distinction between that? And more so when the amount that is 80% is to be recovered by the state government from the central government as per the enactment itself. What you are going to only you are depriving us for no reason at all. Same principle is the Bastia's case, my lords. Item number 8.
Yes.
You have extended it, but you have not given me area salary accordingly. That is why, my lord, that will cover the same principle because they have given the same explanation that we are deducting 85 years because he is not a state selection board sponsor candidate.
Yes, Mr. Patnaik, anything? You have already argued, but still.
PMLA, I had not argued.
No, you had argued in the earlier. It was reserved for judgment. Probably the state has argued.
Yes.
I think Mr. Tripathi or somebody was there at that point of time. It was kept for reserved for judgment.
Because a doubt arose in the mind of my lord.
While preparing judgment.
To be mentioned.
Yes. Only thing is that I'll cut short the time for you. Only thing is that can you make a distinction between the SSB employees, SSB sponsored candidates and the management candidates? whose services the government has approved. It is not that they are simply picked up by the management and asking for UGC scale and career advancement. Their services have been duly approved by the government. So, and there is a judgment of this court in the division bench that you can't make any decisions. Just so on that background, you can make your submissions.
And they challenged it and they lost it in the Supreme Court. What explanation you can give better than that?
Actually, to obviate that, they have brought in this amendment and trying to make it retrospectively applicable. Even notwithstanding that amendment, can you make it? Article 14 is there.
Well, this in the first case, madam. Annexure 3 is under dispute, madam.
Yes, Annexure
It is the rejection order. This Annexure 3 has been passed in terms of the order of the Honorable Court. Now, it has been placed before Lordship, my lord. What is the view expressed as on the date when the order was passed by the State Council? With respect to the issue which was raised here, the grievance of the petitioner, my lord, that was taken into consideration because that has already been decided.
No, Mr. Patnaik, I am willing to, I will go along with you by not looking at that concession, even otherwise.
My lord, that
Let
is
us drop that concession.
That is what my lord submission.
You drop that concession, you.
My lord, in that case, my lord, if that concession is not to be taken into consideration, my lord, at the time of considering the claim of the petitioner, if there is a statutory provision, the authorities are not bound to avoid or to ignore that particular statutory provision while considering the case of the petitioners. Now, at the time of considering the case of the petitioners, the authorities have taken into consideration the very specific statutory provision that without deducting the same, they cannot extend the benefit. Now, here, my lord, two things. One is deduction, another is computation. Here, the deduction part of 5 years is there with respect to such type of persons. So, for the computing part, my lord, this computation is to be started from the very day after deduction of 5 years from the date of approval. Now, my lord, we have stated in our counter, my lord, that why it has been done so. My lord, taking into consideration this aspect, my lord, this is all about the career advancement scale, my lord. Now, this career advancement scale, my lord, that has been introduced in the year 1989. That scheme. My lord, we have annexed Annexure 1, my lord, A by 1. It is at running page 11, man.
Running page 11?
Yes, ma'am. In our count.
In your counter, okay.
Yes, ma'am.
That is this resolution dated 6th October 1989.
6th October 1989.
Yes.
This actually empowers the authorities and simultaneously, my lord, also raising a claim by the employees, my lord, to get the career advancement scale, my lord. Now, so far it's coverage, my lord, 3.1, the first page, my lord. The revised scales and the other measures for improvement of the standard of higher education shall be applicable to all categories of full-time teachers working in all affiliated government colleges and aided non-government colleges, either covered or eligible to be covered under the direct payment scheme till the 1st April 1989. So what we have distinguished, my lord, in this case, while taking into consideration,
you have given a cutoff date. You have given a cutoff date.
Along with, my lord, the word that is direct payment scheme, my lord.
Yes.
My lord, what we have stated in our counter by clarifying the position, the candidates who are actually sponsored through SSP and they are getting the appointment from the very day, first day, my lord, they are getting the engagement against the direct payment. With respect to the lecturers who are sponsored through management or to DPI, my lord, they are getting this direct payment, receiving this particular GIA, my lord, and getting to this particular post, my lord, after 5 years of their approval of this.
So how do you bring them, even assuming what you are saying is absolutely correct, then how would you bring those lecturers or those teachers within the purview of this resolution? Then what you are arguing, it will mean that this resolution will not be applicable to them at all.
No, both of them will, this resolution application applicable to both the categories, madam.
Then how are you making the decision?
Date, madam. Now, since these particular resolutions coverage read with the applicability of the CS scheme, my lord, that says that it is from the date of regular appointment. 8 years from the date of regular appointment. Now, that regular appointment was actually not defined in this 1989 resolution. A clarification was done, my lord, in the in another notification, my lord, of 1990. There an explanation was there with respect to this regular appointment. That was the subject matter of challenge before this honorable court, my lord, which has already been decided, and that has been declared to be that concept of regular appointment, what it was there in 1990 resolution, my lord, that has been declared inoperative. That has been passed. Now, my lord, after that, my lord, after that, this amendment act, my lord, of Annexure B by 1, that has been introduced. And my lord, this has been made applicable with effect from 1/1/1986, saying that, my lord, without touching to the seniority and other service aspects, only with respect to the benefit to be extended in respect of career advancement scale. This is the amendment only to that extent, my lord. So the service condition of the petitioners vis-a-vis the other persons who have been recruited or sponsored through SSB, my lord, that have not been changed. It is, may I be permitted to read
Yes,
that?
yes.
My lord, 4A, the grantee net to be borne by the state government on account of placement of a teacher in an aided education institution receiving UGC scale of pay under the career advancement scheme shall be limited to the extent as may be admissible by computing the period of service rendered by him against an approved post with effect from the date of completion of 5 years of service against such approved post, provided that nothing in the subsection shall be constituted as to effect the seniority of any other or any other condition of service of such a teacher. So, my lord, it is only with respect to determining the benefit in shape of career advancement scale, my lord. What is the period to be taken into consideration and from which date? These are the two things, my lord, which has been taken into consideration here. My lord, this particular provision, when it is very much in force, that has not been challenged in this case, in both the cases, my lord. This provision has not been challenged in favor of the case. So once this provision is very much available.
So let us for a moment go to Annexure 6.
Annexure 6, my lord, with respect to that SSB. Yes, ma'am.
Will it not amount to a distinction, discrimination?
My lord, that is what, my lord.
In view of what has been held by this court in the division bench.
My lord, that is the reason, my lord.
Because this amendment does not nullify the judgment of this court in the division bench, that there can be no distinction between.
They cannot. That there cannot be also, my lord. I bow.
So how do you explain Annexure 6?
My lord, that is what, my lord, we have clarified that particular position. That by way of introducing that 2013 relaxation, my lord, provision, after getting the concurrence from the law department as well as from the finance department, the government decided. The order has been issued by the principal secretary, but it is the decision of the government order.
Government order means the file must have gone to the minister
and
not the cabinet but the minister.
No, by the minister concerned, my lord. So, my lord, here in this case, a decision has been taken in respect of a particular group of persons that there is a clear-cut distinction with this type of persons for whom this 5 years exclusion of the service or deduction of service is not applicable. Now, that has not been challenged by anybody. The other decision, my lord, of the coordinating bench, that it has been presented for lordship. The ratio is that, my lord, once such a relaxation has been extended in favor of one category of the persons, then it can also be extended in favor of other categories. Now, my lord, that is a requirement, and that is what it is to be done at the level of the government while considering the different parameters. When the statute is very clear, that is to be implemented at first, man. Now, if for some reason a particular group is to be distinguished with respect to certain features, my lord, and what is the certain feature, my lord, that we have clarified. Now, my lord, if that clarification it is up to your lordship satisfaction and lordship acceptance. But fact remains, my lord, the authorities took a decision. Neither this act, amended act, nor that particular provision of relaxation extended in favor of the SSV sponsored candidate, my lord. That is not under challenge. So in absence of any challenge to that effect, my lord, the benefit has been extended, taking into consideration what it is available before the government. And the other decision, my lord, there is also no challenge to that amendment act, my lord. Whether that was an issue before the Honorable Court or not, my lord, I have not checked it, my lord. But here in this case, if a lordship will come to the impugned order itself, our order rejecting the claim of the petitioners is solely relying upon this annexure B/1. We have not stated, we have not taken any other ground. But this annexure B/1 has not been challenged, madam.
All right, let us close it.
Yes.
All right. I'm closing it.
One reply, madam. Just with pardon, my lord. Can your lordship come to page 12 of my writ application, that is Ashok Mohanty's case?
Yes, yes.
Paragraph 6, what I've stated and what was the right reply?
Paragraph?
Paragraph 6, running page 12.
Of the counter.
Yes, my lord. WPC 16151 of 2019. Read petition.
Read petition.
That it is respectfully submitted that opposite party number 1 cannot act differently. Persons who were recruited through the state selection board along with the petitioners and also subsequent to that of the petitioners and their services having been approved under the granting principle by the state government are extended the benefit of scale of pay prescribed under the career advancement scheme, computing the date of their approved service and without deducting 5 years thereof. It is worth mentioning here that under the Orissa Education Act and all the granting principle decided under Orissa Education Act, there is no distinction between a candidate who is sponsored through the state selection board appointed by this respective governing body. For appointment as a lecturer, there are 3 courses available under the statute. One is the lecturer appointed by the governing body, another by the candidate sponsored by the state selection board, and other sponsored by the director of higher education. All such appointments were approved by the competent authority, and they have been treated as the approved teachers of aided institutions. And accordingly, they are to be under the gradation list provided under the common cadre rules. While putting them in the gradation list, their approved date of appointment by the competent authority is taken as the basis of placement in the gradation list. The persons approved under the appointment as indicated in Annexure 4 have also been taken into consideration for the purpose of placement them in the gradation list and continuing their service, counting their service. But while extending the benefit of scale of pay provided under the career advancement scheme, such as senior lecturer scale of pay and reader scale of pay, 5 years of such approved service has been deducted, whereas for the selection board candidates who were appointed in the year, the petitioners were appointed, and subsequent that too have been extended such benefit from their initial approved date of appointment without deducting 5 years thereof. Thereby a hostile discrimination has been made by the opposite party number 1. It would not be out of place to mention here that as the approval and grant of career advancement scale has been extended to such persons even after the amendment of section 7C of the Orissa Education Act as referred in the order passed by the opposite party 1 concerned. Therefore, the opposite party number 1 cannot blow hot and cold in his mouth while extending the benefit of the state selection board sponsored candidates and the candidates who were appointed and approved by the governing body. The petitioners have collected information pertaining to candidates who were appointed being sponsored by the state selection board and were also extended the benefit of senior lecturer scale of pay and reader scale of pay along with the petitioners by deducting 5 years of service, but they were extended the benefit of career advancement scale of counting the initial approved date of appointment and thereby antedating the same. So Earlier they were taken 5 years, therefore that 5 years is deducted, another list was prepared. Some of the copies thereof are annexed to the writ application annexed to 6 years. Short approval and extension was given to such persons in the year 2016 and thereafter, whereas the benefit which the petitioners are entitled to in accordance with the ratio decided by the Honorable Court, for which a direction had also been given by the Honorable Court to consider the case of the petitioner in the light of such ratio, has been denied to the petitioner. The same is highly illegal, arbitrary, and discriminatory one. It is to that, my lord, there is no reply. I was verifying the counter that they have not given reply. Only they say that because they are the state sponsored candidate, so that is why they have given. Your lordship, can your lordship have looked to the division bench judgment where they have categorically said, my lord.
No, I have already.
No, they have used the word. The grant of career advancement scale is not a promotion.
Yes.
And this is a one word, my lord, just one word. It cannot, that page 37, last part, it cannot be disputed that UGC scale of pay was granted to the college teachers only as an encouragement and with an idea of improving standard of the education. And before that, they said that it's not a promotion. If the expression that will there. So therefore, once it is not a promotion, and it is for the encouragement of the teachers to get the for their service benefits, that cannot be denied.
My lord, only one clarification, my lord, with respect to that one about the discrimination. Since there was no government, specific government denying that one, though there was a in last para, my lord, there was a denial of all the governments which have not been specifically answered. That is why your lordship directed me to file an additional affidavit, and for which I have clarified that particular position along with the supporting documents.
Well,
that will cover my lord 6 and 8.
Hearing concluded, judgment is up. Parties may file their note of submissions and memo of citations, if any, within a week. This will take some time, so.
Your lordship will give some request.
Yes.
I have given all the.
No, if you have given, then for him it will.
Yes, ma'am. But in spite of that, I will just give a compilation of all the judgments so that your lordship at a glance can get all the things.
Item 6 or 8 Angara. Item 7.
Item number 7. May I please, in this case, my learning scenario is some personal problem. I'll take it on Monday.
Of course. Lordship, they have taken 14 towards 13 time, Lordship. They have enjoying the stay.
Last occasion, this case is not reached.
Thereafter,
the case has been
order sheet there, dekho.
Therefore, adjournment is made on behalf of Sri K.K. Swine, which is seriously objected to by learned counsel for the opposite party, on the ground that the interim order is operating against her client. So, since adjournment is sought for on the ground of personal difficulty of the counsel for the petitioner, the matter is adjourned as a last chance to 9th May 2024, interim order to continue. The parties are requested to come ready for final disposal.
Item number 9. May I please, your lordship.
I'm appearing on behalf of Mr. S.B. Jana. Lordship, on the last occasion, the lordship has directed to take instruction regarding that representation from
Regarding the
DO.
patient, after the thorough search of the files, they
My lord, in this case, my lord.
Yes, any action has been taken against this BO?
BDO.
First BDO.
Yes, BDO.
My lord, I may be permitted to place that. In fact, my lord, today in the morning also, my lord, he told me, but my lord, it is been marked to my lord senior. That is why, my lord, I was under impression, my lord, this case has not been listed.
Yes.
But I may be permitted to clarify what he told, my lord, and what it has been conveyed to me, and that will be filed in separate petition. My lord, there was a direction of this honorable court way back in the year 2001 to submit a repentation, and if a repentation will be submitted, that will be considered within a stipulated period. Seeing that representation, those submitted, but no action was taken. So another writ petition after a period of 10 years, my lord, this has been filed. So your lordship wanted to know that what is the fate of that particular representation which has been submitted during the year 2001. Then, my lord, when your lordship directed me to take the instruction to that effect, my lord, then I contacted the BDO Kirmira. Now, my lord, BDOs were actually the persons, my lord, who were actually looking after the teachers' matter during those days, who were actually appointed within that particular blocks. Now, this BDO, my lord, the present BDO, he has been recently engaged, recently posted there. When I instructed him to get this particular information after referring the books, referring the documents, thereafter, my lord, the BO Jharsuguda, hostile DI Jharsuguda, my lord, the BO Jharsuguda, actually he submitted a detailed information to this aspect. But even if that was produced before lordship, that was silent with respect to the fate of the representation. So lordship once again directed me to get that pinpoint instruction with respect to the fate of that representation, which was filed in the year 2001 before the BDO Kirmira. Now, on the last occasion, when this case was posted, my lord, one instruction I received to me, instruction which was provided to me, that these are the things, the file has already been transferred to the BO office.
I may be exempted.
My lord, that is what, my lord, actually he wrote a letter to me. That is a letter which has been addressed to me, but I presented it before your lordship.
So, you are an officer of the court.
My lord, actually,
you are there to assist the court.
Yes,
you are very much a part of the court.
No, my lord. Actually, he told me in that way that I am not the person who is actually looking after this particular matter, and the entire file is now with the BO. And even after, my lord, the same, he went to the office of the BO, and the BO Kirmira, my lord, actually, my lord, if it can be taken up on Monday, the BO Kirmira, who is not a party in this case, but by virtue of the reorganization of the department, my lord, now all the things are within either BO Jharsuguda or BO Kirmira. Now the BO Kirmira, my lord, he has received all the files from BO Jharsuguda, not even BO Kirmira had not the file, my lord. Now he has collected few of the files from the BO Jharsuguda. Now the BO Kirmira has verified the file, and the letter, my lord, which has been provided to me through my WhatsApp, my lord, that from the existing file, what it is now, no decision is there with respect to any representation. But with respect to the fate of the claim of the petition, my lord, they are claiming, they are praying only for a month's time, my lord, so that this case may be posted after 1 month, my lord, and a decision to that effect with respect to the entitlement, and if not, my lord, what will be not, why it will be not, my lord. Everything will be made clear and it will be placed before lordship. But he actually in that particular correspondence, my lord, he had also written that for unconditional apology, my lord, because that was a letter actually he had addressed to me. He had no intent, even he had not even the knowledge, my lord, that it will be presented to your lordship and your lordship will take the cognizance of this. And so actually he wanted to personally come to before lordship.
No, why? If necessary, I'll call him. Otherwise, why should he come?
But this is the information, my lord, the entire scenario, my lord, what it has been collected from the different offices. I have contacted the office of BDO Kirmira, BEO Kirmira, and my lord, may I permit it, for the effective implementation of the order, even, my lord, what your lordship is going to pass after the final conclusion of the case. Since after the this is a
so
case
you should make them a party.
BEO Kirmira may be implemented as a party.
Implement them as a party.
Yes,
on the oral prayer of Learned Counsel for the petitioner, Block Education Officer Kirmira, in the district of Jharsuguda.
Jharsuguda, sir.
The district of Jharsuguda is implemented as opposite party number 7. Necessary correction to the cause title be made in the court. Yes. Learned State Council submits that the relevant files have been obtained from the concerned block education officer, and he requires some time to go through the same to answer the query posed by this court in order dated 19/3/2020. Only what action was taken on that?
Yes.
List this matter on Monday, 6th May.
My lord, with respect to, I can hand over, my lord, all the correspondences what it has been made.
No, you'll have to just find out, go through the file and say what, if you say that no action was taken on that representation.
ହେଇନି ପ୍ରକୃତରେ
ସେଇଟା କହିବେ ଆପଣ?
ନାଇଁ ସାଇମଲ୍ଟେନିୟସଲି ସେମାନେ ମଧ୍ୟ କହୁଛନ୍ତି ଯେ ତାଙ୍କର ସର୍ଭିସ ବୁକ୍ ଆଉ ଫାଇଲଟା ତାଙ୍କ ପର୍ସନାଲ ଫାଇଲଟା ଦ୍ୟାଟ୍ ଇଜ ନଟ୍ ରେଡିଲି ଟ୍ରେସେବଲ ଯୋଉଥିପାଇଁ କି ବର୍ତ୍ତମାନ ଯୋଉ ତିନିଟା ଅଫିସରେ ଯୋଉ ଟ୍ରାନ୍ସଫର ହେଇକି ଅଛି ଦେ ଆର୍ ସିକିଂ ଓନ୍ଲି ମାନେ ଏବେ ବର୍ତ୍ତମାନ ଯୋଉ ଇଲେକ୍ସନ ପାଇଁ ମଧ୍ୟ ସେମାନଙ୍କ ପାଖରେ ମାନେ ରିଓପନିଂ ୱିକରେ ଯଦି ଏଟା ରହିବ ମାନେ ୱିଥ ମାନେ କଂକ୍ରିଟ ଡିସିଜନ ଅନ୍ ଦିସ୍ ପର୍ଟିକୁଲାର ସବଜେକ୍ଟ ମ୍ୟାଟର ମେଲଟ୍ ୱିଲ୍ ବି ଫରୱାର୍ଡ ୱିଥ୍ an affidavit. That may be.
No. This must also be on affidavit. This must also be on affidavit since the judicial.
Yes, I'll do that.
Because the judicial order has been passed. So let him file an affidavit saying that no action has been taken.
BO Kirmira or BDO Kirmira. Both of them will file the individual affidavits.
No, BO Kirmira. BO Kirmira.
Yes.
Let's this matter on the 9th of May. 9th May. On which date? The BEO Kirmira shall file a representation answering the query posed by this court by order dated 9/4/2020.
Yes.
I cannot then.
Maybe taken up after that.
Yes.
BO Kirmira will file an affidavit.
File an affidavit. That's will file. Then if he says so, then we can adjourn it to after vacation. Yes.
Maybe taken up after vacation, man. I will take instruction.
2011 matter.
See, old matter regarding appointment of Sikya Sahak.
No instruction.
No instruction. Whether petition is in service. No matter. I will take instruction. Maybe taken after
Might
vacation.
have been engaged somewhere else.
Yes.
From
We will
2011.
keep it pending to after vacation. 2011 matter.
ଜାଣିନି ସେ ଅଛି
No.
counter not file last ଟା କେଜାଣି
I was directed to file the affidavit. The draft is ready.
Yes.
That I can.
I call it next week. Let AG submits that. How about next week? Island State Council submits that he is ready with the Parawai's comments and would file the affidavit, file the counter affidavit within a week. List this matter on 17th May.
Okay.
I don't know 11.
Well, it's not question involved in this case is whether the petitioner is entitled for the interest for the delayed payment from the date of her retirement to the date of his payment.
No, yes, I remember. I think our rule 47, Odisha pension rules, rule that it is, whether it is applicable to the OUAT employees or not, that was the question, if I remember.
Section 7, subsection 3A also of the Payment of Gratuity Act says payment of interest. And I so 2-3 judgments of the Supreme.
Yes, please. Yes, please. You want to place this?
Aye. In this case, non-payment of death cum retirement gratuity extended to the employee with interest who have retired from the service during the period from 1/1/2006 to 30/11/2008 is the grievance of the petitioner. The following prayer has been made in the present writ petition. In this, it is therefore prayed that the Honorable Court may be pleased to admit the writ petition and issue notice to the opposite parties to show cause as to why the balance amount of rupees 5 lakhs towards death cum retirement gratuity shall not be paid to the petitioner as per the resolution dated 2/4/2011 Annexure 8 of the state government in finance department with statutory interest and further interest on the amount till actual payment is made within a stipulated time fixed by this honorable. If the opposite parties fail to show cause show any cause or show irrelevant insufficient cause, the Honorable Court, after hearing all the parties, may be pleased to issue a writ of mandamus directing the opposite parties to pay the balance gratuity amount of 5 lakhs with statutory interest as provided under the provisions of the Payment of Gratuity Act 1972, and further interest for illegally withholding the gratuity amount without making payment by the opposite parties to the petitioner within the date stipulated by this Honorable Court. But I am placing the date 2/4/2011, the resolution Annexure 8, the resolution of the Finance Department extending the benefits to the employees who have retired during the period from 1/1/2006 to 30/11/2008 are entitled to death cum retirement benefit up to a maximum of 7.5 lakhs with effect from 1/1/2006. 37/2007. The petitioner retired from the service with effect from 31/7 to 2007, 31st July, Annexure 6. Thus, she is entitled to the benefits granted by Annexure 8 to receive the death cum retirement benefit at the enhanced rate of 7.5 lakhs since she has retired from service with effect from 31 July 2007. 7/6/2011, petitioner lodged her claim and requested the opposite party number 1 and 2 to make payment of the balance amount of 5 lakhs immediately. Annexure by Annexure 9. 31/2012, she issued reminder to make payment of the death cum retirement gratuity as per the resolution of the Finance Department by Annexure 8 at page 20 by Annexure 8. 14/2/2012, the petitioner was informed that Finance Department was moved to obtain concurrence to pay the DCRG with effect from 1/1/2012. 9/4/2012, petitioner informed to the opposite party number 2 that since in the meantime OUAT has received the concurrence from the Finance Department to pay the enhanced gratuity, the same may be paid to her at an early date. 12/6/2012, the opposite parties did not deny that the OUAT has received the concurrence, but the accounts officer informed the petitioner that such concurrence has not been received by the accounts division of the OUAT.
Yes.
The petitioner is entitled to receive statutory interest as provided in subsection 3A of section 7 of the Payment of Gratuity Act. In this connection, I will file 2-3 judgments of the Supreme Court and also other state high courts. One is 2012 Labor and Industrial Cases 3648. It is Madras High Court judgment. I will give you. AR 2003 Supreme Court 1526. AR 1985 Supreme Court 356. AR 85 Supreme Court 356.
Yes.
Constitution of India, Article 311, 300A, retirement dues, delay in payment, liability of government to pay interest at the market rate, commences from the expiry of 2 months from the date of retirement. Government employee delayed payment of retirement dues due to non-production of last pay certificate by the retiree. Suit for interest. Non-production of certificate held was due to lapse of issuing authority. Government liable to pay interest. Such and such. Pension and gratuity are, it is paragraph 1 and 2. The pension and gratuity are.
Settled position of law is accepted. And
Then
then
next time.
for gratis. or bounty to be distributed.
Yes, but in that line.
Yes.
2012 LIC 3648. Payment of gratuity, delayed payment of gratuity, interest on entitlement, death cum retirement gratuity. Gratuity amount was disbursed after 8 years of retirement of employee. Employee was not responsible for such delay. Employer denied to pay interest on the ground that excess payment was already paid to the employee due to wrong pay fixation. However, order of pay fixation was already cancelled and authority ordered that employer would not withhold the payment of employee. For inordinate delay in payment of gratuity, employee held entitled to interest from the date of retirement till actual date of payment.
Yes.
Year 2003 Supreme Court, one, so it was held that the petitioner is entitled to gratuity, and if the delay is made not for the in this case, they have paid 5 lakhs, no doubt, and as per Annexure 8, the notification. But I am claiming interest on this 3A, 7, section 7, subsection 3A. Also, kindly see section 7 and 3A.
Payment of gratuity act.
Section 7.
Payment of gratuity.
Determination of the amount of gratuity. A person who is eligible for payment of gratuity under this act or any person authorized in writing to act on his behalf shall send a written application to the employer within such time and in such form as may be prescribed for payment of such gratuity. As soon as the gratuity becomes payable, the employer shall, whether in application referred to in subsection 1 has been made or not, determine the amount of gratuity and give notice in writing to the person to whom the gratuity is payable and also to the controlling authority specifying the amount of gratuity so determined. Subsection 3. The employer shall arrange to pay the amount of gratuity within 30 days from the date of it becomes payable to the person to whom the gratuity is payable. This is subsection 3A I am reading. If the amount of gratuity payable under subsection 3 is not paid by the employer within the period specified in subsection 3, the employer shall pay from the date on which it is paid simple interest at such rate not exceeding the rate of notified by the central government from time to time for repayment of long-term deposits as that government may by notification specify. Other things are there, they're not relevant, but subsection 3A, section 7 shows that the petitioner is entitled to for the interest on late payment of gratuity.
Yes. Simple points, Milord. Initially, it was not there in the regulation of the government in the year 2011. April 11 notification by the Annexure 8 that was decided by the government to enhance the discharge amount. But it was not applicable for the university. So therefore, in the month of July 2011, this matter was placed before the Board of Management. The Board of Management approved. Accordingly, in the month of August 2011, the communication was made to the government to release funds so that the differential gratuity amount can be paid to the employees. Till 2012, we have not received. So accordingly, we have sent also letter intimated to the petitioner that yet we have not received the funds from the government. As soon as we receive the funds from the government, the differential amount will be paid.
Yes.
In 2013, the amount was paid. We received the funds, and 13, on the last occasion, I submitted the instruction with us till 11 May. That the person who retired between 2006 to 2008, they will be entitled for the gratuity amount. That was not applicable for the university employee. So therefore, in the month of July, this matter was placed before the Board of Management. Accordingly, letter was sent to the government to release funds so that the differential gratuity amount can be paid. Till 2012, we didn't receive the funds from the government, therefore we could not pay. We have also intimated to the petitioner. Petitioner also made representation time and again that I understand that the university has moved to the government for release of funds. Now I understand that you have received the funds, so you, to 12, last letter your lordship may see. Page 27, annexure 12 of the writ petition.
Yes.
That is the letter representation made to the University Miller. My reminder dated 31/12 on the above subject, OUT replied 14/2/2012. In your above reply to my reminder, I was informed by the OUT that it has moved the Agriculture Department to obtain the concurrence of Finance Department to pay the enhanced gratuity of 7.5 lakhs with effect from 1/1/2006. I understand now that the OET in the meantime has received the shot for concurrence to pay the enhanced gratuity from 1/1/2006. If so, the balance gratuity of 5 lakhs be paid to me without any delay and amount deposited in my savings bank, account number so and so in OET campus branch of the State Bank of India under intimation to me. Next, your lordship may page 28. That was the letter issued by the account officer to the letter dated 12/6/2012. Page 20 is annexure 13 of the writ petition. Payment of differential amount of discharge under GPF scheme. Your letter dated 9/4/2012. With reference to your letter on the subject cited above, I am to inform you that the concurrence of the Finance Department, Government of Odisha for payment of discharge at the enhanced rate of 7.5 lakhs to the OUT retired within effect from 1/1/2006 has not been received so far by this division. After receipt of the same, your case will be considered as requested by letter under reference. Thereafter, the university received the funds, and on 28 September 2013, the differential gratuity amount of 5 lakhs was paid to the petitioner. So my whole submission is that there was no laches on the part of the university to pay the differential gratuity amount. The moment the notification was issued, just 2 months after, the matter was placed before the Board of Management. Necessary communication was made to the government to release of funds. After the release of funds, because in 2013, the differential gratuity has been paid. So there is no laches on the part of the university, so we are not liable to pay interest on this. This is my whole submission.
The question is, when the statute prescribes interest,
yes,
and does not provide for any laxity on the ground of non-availability of funds, etc., can the university take such a plea? This is the question to be answered.
Yeah, that's true, Miller. But the question is that was
you have referred to the sequence of events,
yes,
saying that you had written to the government that a resolution was made applicable, and then funds were released.
Yes.
So in the process, there was some delay.
Yes,
there was some delay.
Yes.
Now, does the statute provide for condonation of such a delay on the ground of administrative reasons? That has to be considered, Mr.
It is actually
whatever reason,
yeah,
that
that has to be considered. But what I say, Miller, the notification was issued.
Let us go to the pension rules.
2011.
Let us go to the pension rules.
Yes, madam.
For assuming for a moment that they are applicable, knowing that they are not applicable, but for just to see the language.
Yes, madam.
What does it say? To understand the intention of the legislature better,
Yes.
I will also refer to the PG Act.
Yes, madam.
It says, what is it, section 47 or what?
49, man.
49.
Yes.
Just to, for my understanding.
49.5.
Yeah, 49.5.
Yes, sir. I pay.
Where the sanction of payment of gratuity is delayed for more than a year from the date it is due under sub rules 1 or 2, or as the case may be, and such delay is attributable to administrative lapses. Here they have qualified it, administrative lapses. Interest at the rate of 7% per annum for the period beyond 1 year shall be payable on the day amount of gratuity. Now, what does the PG Act say? PG Act is a central act. It does not say anything. It does not qualify. It only says that no such interest shall be payable if the delay in the payment is due to the fault of the employee, and the employer had obtained permission in writing from the controlling authority for the delayed payment on his ground.
But here in this case, my lord, it is to your first assumption that whether the payment.
PG Act, whether it is applies to.
Orissa pension rule. Because in Orissa pension rule, there is.
I have read out both the rules. That is why.
No, there is another provision, sir.
What is that provision?
My lord, in that rule 49, after in rule 49.5, my lord, if
Page ta kete koile?
no, 61.
Page kete?
61.
Same boy to?
Bus,
No.
Rule 49, ebbe sir.
Folder मतलब ये कर देली. तो flag मारी पहले नहीं. Very badly, arranged. Very badly arranged. Yes.
My lord, rule 49.5A, just now your lordship read. My lord, after that, my lord, E, 49.5E, no interest shall be payable under this sub rule.
I've seen it.
Where?
Yes, yes.
Yes, my lord, that is Roman 2, my lord. The amount of gratuity already paid to a pensioner is enhanced on account of retrospective revision of pay scale or amendment or liberalization of rules affecting the quantum of gratuity consequent upon the government decision taken subsequent to the retirement of the government.
This is not applicable.
This is also not applicable because Annexure 8 was issued in the year 2004. It was subsequently made applicable to the employees of the university. Now, the delay was not on account of making it retrospectively applicable. It was already made retrospectively applicable. The only thing is that release of funds.
So, my lord,
Release of funds.
to that extent, my lord, because rule 49.5A is also very clear. Because why I am saying so, my lord, Annexure 8, on the basis of which, my lord, they are making a claim, my lord, in this case. This is referring to pension rule. This is not referring to that.
No, even under the pension rules, I read out the pension rule also.
So,
I consciously read out both the rules.
49.5
Because insofar as Payment of Gratuity Act is concerned, then there will be a question of its applicability. Let us not get into that.
49.5, my lord.
Let us not get into all. I am closing it, sir. Hearing concluded, judgment is up. It is not कौन देवे? जल्दी देवे तब? हैं? नहीं रखिए ना रख. Yes.
Okay.
Item note 12.
No, last day, your lordship has directed me to take instruction.
About what?
Lord, whether there was any
As per clause 12 of the agreement, the collector is competent to take disciplinary action, including removal of GRS for unsuccessful after getting feedback from the concerned GP through without obtaining necessary feedback from the concerned Gram Panchayat.
My lord.
Yes.
Lord, I'll file counter, detailed counter I'll file.
What counter?
Lord, for example, there is no such feedback given by the Gram Panchayat.
Then end of the matter.
No, so subject to lordship acceptance, what I'm trying to say, my lord, there is one notification issued by the Panchayat department that the collector also is empowered to initiate disciplinary action against the GRS.
Now, this the provision which my learned senior is relying upon is one of the condition enumerated in the agreement executed with the Gram Panchayat and the GRS. But so the collector being the head of the disciplinary authority, my lord, being the my lord, chief chief executive officer, my lord. So he is also equally empowered to take disciplinary action. He was issued with the show cause.
But on facts,
My lord.
he says,
My lord.
let us see the show cause.
Yes,
Show cause is the online report that your performance regarding job card verification and Aadhaar seeding is very poor.
my lord.
So and so 28% and he submits his reply. And whether his performance with record was found to initiate disengagement proceeding. Poor performance regarding job card verification, Aadhaar seeding and generation of personal
Generation of percentage.
percentage.
My lord.
The collector. The achievement against the target given to him regarding Aadhaar seeding, job card verification, generation of percentage is 31. All right, you file a counter.
Right.
Sri S.N. Das submits that as per instructions received by him, the collector is also empowered to act independently against an erring employee. In this regard, he would like to file a counter. And that in this regard, he would like to file a counter. Such being the case, list this matter on very short date ago. 17th May. Counter if any be filed in the meantime, after serving copy on the other side.
Interim order to copy.
Interim order to confirm.
Item number 13. Item 13, that creation of a post of driver under the university. Stand of the government has not been brought by affidavit before your lordship. That for that I seek a adjournment.
What is the matter?
Post of a driver, the university has created, but the government has so far not acted on the creation. So that instruction I will have and file by way of affidavit.
Sri Ardas Learned AGA submits that he has received the instructions and would file a counter affidavit. Yeah, within a week. List this matter on 17th May. Counter affidavit, if any, be filed in the meantime after serving copy on the other side.
Item number 14.
Last section has taken to file the counter affidavit.
Notice issued to OP number 4.
OP number 4.
I pray for file the counter. I am appearing for 5, but notice issued to OP number 4 as it was returned. Your lordship kindly.
Notice was returned.
Earlier returned. Earlier not returned. It is also not back.
The tracking report of notice issued to OP number 4, which is at flag B, shows item delivered. Postal tracking report shows that notice on opposite party number 4 has been duly delivered. There is, however, no appearance for which the
I will, next week I will file the counter for OP number 5.
The matter for which the bail application is the writ application is taken up for hearing. Sri Das Learned Counsel appearing for the opposite party number 5 requests for some time to file counter affidavit. Raise this matter. Yeah, vacation per asu. 28th June. Counter if any be filed in the meantime.
15.
May I please
Correct, pass over.
Item number 16.
16, somebody had made a mention in the morning.
May I please, my lord? On behalf of Mr. S.K. Dwivedi.
Yes.
Item 16.
Therefore, adjournment is made on behalf of Sri S.K. Dwivedi, Learned Counsel with the petitioner, on the ground of bereavement in his family. List this matter. Vacation for record.
Sir, 28th June.
Huh?
28th June.
List this matter on 28th June.
Yes.
Item
16 and 28.
28 podu. 28 podu beste kya? Yes, item 17.
Oh, bless my lord.
Please, your lordship. Petitioner before my lord is the deserted wife.
Has anybody appeared?
My friend Mr. Das is appearing.
Very good.
Till date, not a single pie since 2019, my lord.
Settle the matter.
Despite direction of the court.
TRPC आरंभ कले पैसा रु आया पैसा रो मतलब मेडिएशन को जाओ
Because you should not disclose the since you have asked what is the intention. Mugli, she is not getting a single rupee.
Mediation हो जाओ
How should- if this is if this
No. Asking for maintenance by the wife who claims to be deserted is nothing wrong.
yes.
So why are you worried?
Since because you asked what you want, I say this is my instruction.
No.
Litigation.
Wait. Smile. If he's saying so, let us send it to mediation.
As a good gesture, at least he should pay something.
That order cannot be passed in a transfer application.
As in today, my lord, 5 lakhs is outstanding. Not a single rupee. He is not attending their money.
Say the final.
I'm grateful my friend is appearing here before my lord. At least having a child.
Well, let us send it to me. Who is a case?
Now my friend has filed a divorce proceeding at Bhadrak.
Both belong to
There are two
Bhadrak.
proceedings are continuing.
ଗୋଟେ ମିନିଟ ଆଜ୍ଞା ଟିକେ ରୁହନ୍ତୁ ଟିକେ ଆପଣ ଏମିତି ସମସ୍ତେ ଯଦି ଏକାଥରେ କହିବେ କେମିତି ହବ?
Yes, sir.
I'm trying to find out a solution.
Yes.
My lord.
Two
I will
proceedings.
send it to mediation. Where? The question is where? To which place?
Bhubaneswar, there are two proceedings, DV and maintenance.
Well,
Two proceedings, my friend's client is attending.
Hmm.
Now he filed a case
at Bhadrak.
at Bhadrak.
All right. I will direct both of you to appear before the mediation center at Cuttack in the High Court mediation center. That will be better? Yes.
Probably, my lord, but my sincere to my friend, at least he should suggest to
You make that request to your friend. Can he pass us an order?
No, therefore, since my friend is raised that question, the tamar paisa re matlab, since because you asked what he want, how he will survive, at least you should think up. You should insist your client.
All right.
5 lakh is
In course of hearing, it is stated at the bar that the nature of dispute between the parties is such that an attempt can be made to settle the same amicably through the process of mediation. Such being the case, let the records be placed before the coordinator Odisha High Court Mediation Center, who shall do the needful. The parties are directed to act upon receipt of notice from the mediator and to render full cooperation in the mediation proceeding. Place this matter
5th July.
on 5th July, interim order to continue.
Item 18.
Item 18, yes.
And today I am seeking for time for filing of the counter, my lord.
What counter? Counter कौन इथे transfer application?
Some matter of fact is available. In the meantime, I have also humbly requested
want some
letter to the mediation, my lord. There is no dispute between the husband and wife, my lord.
Because Rayagad,
Sir, Mr. My lord, sir, please kindly, sir.
petitioner my lord, the lady my lord, wife my lord, she is residing at Rayagad my lord. And husband is residing at Jatpur. I have a mentally retarded child of 5 years. And nobody is looking to him. And the restitution of conjugal right has been filed by the husband my lord. May I pray my lord, let the matter be transferred to, I am ready and willing to stay with him. Because as per the doctor's advice, I am ready.
No, my
residing
lord.
at Rayagad.
There is
Let the elder counter.
My lord, some matter. One of the cases is initiated in the Rayagada
Yes.
by the present petitioner, my lord. The present petition is not deserted by the husband. Some material facts are suppressed before your lordship. That's I am for filing of the counter, my lord. But my lord, after the death, there is no dispute between the husband and wife, my lord. After the death of the mother of the present petitioner, she is residing in Rayagad. Bangalore and doctor, regarding the advice of the doctor, there's mislead to the court, my lord. Doctor, let me complete, my doctor is clearly stated that the treatment is better available in the state of Bangalore, my lord. The present opposite party is serving at Bangalore. See, सेठी रोची treatment सेठी होगा, किंतु जेहेतु मरी गला, बापा ही father of the present petitioner माला, they creating the entire scenario.
First of all,
GOD kind of
before I go further, my question that I pose to both of you is,
Madam, mediation center.
Is it possible, Mr. Ponda, for your client to, make an attempt to resolve the dispute amicably? Because you have yourself said that you are willing to reside with your husband.
I hope so that matter will be settled. Let the matter be transferred to Raigada. I am also.
That is allowing your.
See, my lord. Sorry.
Because my lord's entire, my lord's, I have.
That will be allowing your transfer application. I am asking you for mediation, whether you agree or not. The court is not forcing you. If you don't agree, you don't agree. I will ask him to file a counter. I will consider it.
Mediation at Kotak, my lords.
Obviously,
because my lords, I have mentally retarded child. That is
of course.
Nobody looking to him, my lords. No.
So where are you residing?
I am residing at the interior part of Raigada, my lords.
Raigada mediation of will hear it on merits.
Near my place, my lords.
Bartan Suara treatment in Higbarun.
All right. Learned counsel for the opposite party wants to file a counter affidavit. List this matter on.
The 17th.
No, Chuti par.
21st June.
21st June. Interim order to continue. Yes.
Item 19.
Mediation को मतलब जाते हैं better क्या ना छुआ.
आप जिबे रायगड़ा डीएलएस से कुछ जिबे mediation पे. Graduation में sanction कर दी. DLS Raigada. The lady with an autistic child, who is your child, yes, cannot be expected to come to Kotak with that child. Autism is very serious. It's a very serious and it's very difficult to handle. Very difficult to handle.
All the doctor and medical documents are all available.
I have filed.
Counter file karibi.
It is your child also.
Yes.
If you are willing, sir, if you are willing to travel to Raigada to attend mediation, just now I will pass that out.
Password
next week.
Password se phone I'm here for the entire day. List is almost over.
At 2 p.m.
At 2 p.m. What matter? After lunch, no? Whenever you are convenient.
Let us counter file.
To take instruction.
Next week, yes. Next week.
Yes. We'll take it up after vacation. Item 19.
19, my lord, notice was issued.
Yes. Notice was issued.
Yes, my lord. We had filed an application for transfer.
Postal tracking report may kindly be seen. Postal tracking report, yes. Postal tracking report shows that notice on the opposite party has been duly delivered on 15/4/2024. There is, however, no appearance from his side. List this matter in order to grant an opportunity to the opposite party, one more opportunity to the opposite party to appear. List this matter after vacation for
21st June.
21st
June.
21st June, interim order to continue.
Item 20.
20 the same. I said 20 was some prayer was being made. Oh, see, dividing karo matter kate 20. Item 20, yes.
20 I am for the petitioner.
Yes.
But the other side, I am for the opinion.
Yes.
May I suggest something subject to your lordship?
Yes.
Please approval. Mediation center, can we go?
At Kotak? High Court Mediation Center?
Kotak.
Learned counsel appearing for the parties submit that the dispute between them is such as can be attempted to be resolved amicably through mediation. In such view of the matter, let the records be placed before the coordinator, Odisha High Court Mediation Center, who shall do the needful. The parties are directed to appear pursuant to notice received from the mediator and render full cooperation in the mediation proceeding. Let this matter in the
5th July.
On 5th July. Is there any interim order?
Yes. Interim order.
Interim order to continue.
कितने जुलाई?
5th July. 5.
छुट्टी पड़ी जो मासरे मेडिसिन सेंटर चालू होगी नहीं.
चलो. Mediation center से ताकत होता vacation है ना? Because it is by the State Legal Services Authority.
Ultimately, mediators are the lawyers. So, देखिए how it's.
Very good mediators are there, trained mediators.
They are trying. Of course, they are trying. In 3 to 4 cases, in my case, because of their intervention, because of their insistence, it has been maintained.
Yes, many such lawyers. And the lawyers from this bar alone are the.
Will it be possible for the lordship to dictate that in course of hearing it transpires that matter can be mediated between the parties?
That is what I've said.
No, parties agree for mediation.
I said the learned counsel say that.
We said that, but many things we say.
So what do you want me to say?
Court feels it proper.
Stop, because first line after going through the pleadings, this court is also of the view. This court is also of the same view.
ନା ଆପଣ କହିବେ ଆମେ ଏଗ୍ରି କରିବୁ
ହେଲା ନାଇଁ ଆପଣ କହିବେ ଆମେ agree କରିବୁ ଆମେ ଆଜ୍ଞା କାଇଁ କହିବୁ
ସବୁ କଥାରେ ତ ହୁଏନି ନା ସେଟା
The court does not have any advisory jurisdiction.
No, when we say court normally do not have.
No, no. The court is here not to agree.
They are there to oppose everything what we say. No, my lord. They begin with no, my lord.
Item 21.
Yes, Mr. Panda.
Item 29, appearing for
The opposite. Very good. I pray for some time to file class. Mediation.
I have to take instruction, my lord. Today I have
Sri Agnihotra Sahu Advocate and Associates have entered appearance for the opposite party by filing Wakalatnama. Same be kept on record. Their names be reflected in the cause list and the brief. As requested, list this matter. No, vacation. 21st June. Interim order to continue.
Okay.
Item 22.
For extension of interim order, the lordship grant interim orders to the present petitioner, and he was for 1 month, and he was released on bail on 4/4/24, my lord. And for treatment of his father, I have announced his father suffering for chronic kidney disease, my lord. Read 1 month more time. I have copies of already informant belongs to same area. She also knows, and
I'm for the informant,
and also
no
copies of.
It is submitted that it is submitted by Mr. Das and comes up to the appellant that the treatment of his treatment of his client's father is still going on, and that there has been no substantial improvement. He therefore requests that the interim bail granted be further extended. Learned State Council has no serious objection to the extension to the prayer. Considering the submissions as above, the interim bail granted by order dated 27/3/2024 is further extended by 3 weeks.
4 weeks.
Yes.
4 weeks.
Item 23.
23.
May I please note? No, I have filed my lord interview application for extension of obligation.
I filed for extension of interim bail, my lord.
How many times? How many times has it been extended?
2 times.
No.
My lord, the petitioner is the handicapped.
Therefore, extension of interim bail is rejected. Yes.
My lord, in the meantime, he is suffering from chickenpox, my lord, and the doctor also advised to rest 15 days. That's the last chance, my lord.
Acha, prayer for considering the submissions, prayer for interim bail is extended by a further period of 10 days. It is made clear that no further extension shall be granted.
15 days, my lord.
Item 25.
Item 25.
Permitted to withdraw.
Well, item 24, copy in course of the
No.
last day.
ସବୁ ତ ଆପଣଙ୍କର ଦରକାର ଆଉ ସବୁ ଆପଣଙ୍କର ଦରକାର ଆଉ copy in course of the day. Yes. Item 26.
Maybe.
Your matter. Your matter. ଆପଣ ନାଁ ନେଇ
ଅଛି
କୋଉଠି ଅଛି?
ଏ ବିଲ୍ ଏପ୍ରିଲ 2748 ଅଛି।
ଓ ସେଇଥିରେ
ସେକେଣ୍ଡଟାରେ ଅଛି ତାଙ୍କ ନାଁ ସେଟା ସେକେଣ୍ଡ ଟାଇମ ଫାଇଲ ହେଇଥିଲା ବୋଲି ଫାର୍ଷ୍ଟ ଟାଇମ ଏଟା ହେଇଥିଲା ସେଥିରେ ଅର୍ଡର ହେଇଥିଲା ଟୁ ସରେଣ୍ଡର ଆଣ୍ଡ ମୁଭ
yes yes
ବେସିକାଲି ମର୍ସି ପିଟିସନ
ନେ କୋଉଟା କୋଉଟା ଖୋଲିବା ଦିଟାଙ୍କ ଭିତରୁ କୋଉଟା
malad as malad that
first matter I have opened the first matter. Yes, what is that?
bill number 1264659 malad we see the photographs
then
and dispute relating to the
ठीक है देखिए एटा फर्स्ट हैला 2023 रो एटा 2020 subsequently I had to ask you to file a modification petition. Let us see.
That I cannot say, but
withdraw करो. The bill appeal number 2748 of 2024 permitted to withdraw. In this case, what do you want?
foreigner release
कौन है इसी इतने मैंने
इसे दीटा existing मतलब dispute between two
offense था कौन?
Offense है 420. Document should have based on which subsequently the service of some persons were regularized. They approach the tribunal. It has been confirmed. Subsequently, they approach this honorable court. Confirmed before writ appeal. Confirmed Now they are saying the documents based.
Now tell the, please assist the court as to how that order can be modified. अच्छा कोई भी नहीं किया
My lords. That's why from the very beginning I said it's a mercy petition.
What mercy petition?
Because of the age, because of the photographs.
The court will have to invent a reason.
It is only my prayer.
The matters be
That order dated 3/11/23.
Yes.
Yes, to surrender and move, and it will be considered on its own merit.
It was just under. Okay.
Sri M.K. Sri Manas Kumar Chand, learned counsel for the petitioner, submits that this court, while passing the order dated order on 3/11/2023, actually intended to direct the petitioner to surrender and to be released on bail, and dictated the order accordingly. Inadvertently, the same was typed as typed to the effect that on his surrender, his bail application shall be considered on its own merit. Stop. Learned State Counsel also fairly submits that the court had intended to pass such an order. The court had intended that the petitioner should surrender before the court below, and in such event to be released on bail. Stop. But somehow the same has not been reflected in the order. In view of the submissions as above, the order dated 3/11/2023 is hereby modified. Modified to the extent that paragraph 5 thereof be substituted as follows. Look, since NBW has already been issued, comma, let the petitioners surrender before the court below and move for bail, and in such event they shall be released on bail on such terms and conditions as the court below may deem fit and proper to impose. केतरा नहीं चिंती
टंका नहीं है जो कागज जोड़ा जोड़ा कंफर्म करले सब्सिक्वेंटली सेटा हम जालियाती करलु माने फर्ज करलु बोली कहउछन.
On such terms and conditions, including the condition that they shall personally appear before the. नहीं सेटा करे
ये लोकोडा देखन दे तो मान लो सी दी फोटोग्राफ्स
कोन हिसाब रो
किछि नाही हो तांगर
किछि नाही हो
जणे तार अपील करि परियो पीरियड जो 2 टा से होची बाकी जो 2 जण आगे अछंती किछि माने दे आर नॉट इन द पोजीशन बट बेंड डाउन के किछि नाही.
Such terms and conditions as the court below may deem fit and proper to impose.
Item 27.
Please thank the State Counsel. Please thank the State Counsel.
Outside.
I'm not saying it right now.
But in item number 37, my lord.
37?
27. My lord, on 26/4/2024, my lord.
Yes.
There was a direction to the State Council to obtain the status of the 2 colleges or one college, Santilata Mahavidyalaya.
Yes.
I have already written a letter, my lord, but this matter may be taken up next week. In writing, my lord. Because in the second case, my lord, where we have where the impugn order is there, my lord, at annexure 8, the order has been passed.
Because I have heard it at length.
Yes.
Yeah. Yes. I think the senior counsel has completed. Mr. Das is to complete. Oh, Mr. Das has completed.
No, my senior is.
Acha.
Only point is. Only point, my lord, when the division bench has confirmed the fact that there should be 2 colleges. So, with due respect to my lord's order, because other they also have stated so, but my lord have not accepted my submission, I am repeating it. So now this instruction, whatever, it will go against the order of the honorable division bench, and that is also not the issue now. What I am raising in this case, only thing my claim in this case is, which has been disposed of, the government is to cause an inquiry. A review has been filed.
Anyway, a judicial order has been passed. If he wants time, let it come next week. We'll complete it on next week.
Yes.
On the condition that there will be no further adjournment. It will be closed on the next week. You have completed your argument.
No, not completed. I have stated on with regard to that maintainability of the writ petition.
I have taken note of
the review petition, sorry.
I have taken note of whatever you have said. I have taken note.
My lord.
So, I'll say, as requested by Learned State Council, is this matter next week?
Next week.
Since, but how? On the condition, on the understanding that it will be completed on that. 17th. He's asking, next week, 17th May.
But the entire endeavor with due respect now, this particular college matter now continuing in 3 honorable benches of this honorable court. Issue is almost the one and the same. The forgery and manipulation of record, payment of gratuity to the persons, those who are not entitled to. It is one of the case. And because now the entire endeavor will be at the, because I have an allegation against the government also. In the other day, yesterday, another matter before honorable on another bench. There the same direction was given. To produce the record. Government officers are hand in glove with the person, those who have not taken the gratuity, died from 99.
Yeah, that's all right.
So now, because 17th, my lord, the last working day will be 21st. I think 17th will be the last working day. So on the same thing. Also, Guruvar din asu 9 तारीख की बात
No, nahi. See, Arthur शुक्रवार nahi to. Arthur say that is causing all the problem.
Arthur
4 दिन a week na.
Guruvar को जो कोई दिन वो डेट कितना होगा? Only issue is this.
कोई दिन को adjust कर. अरे week. हाँ? 13th May.
Okay.
Is this matter on 13th May? Huh? We'll close it on that day.
Yes, please. Item 28.
28 is same order. Just to the karo. The bereavement achi so again. His father has. Oh, item 28.
28 item myself.
No, item 28. You are there for the opposite party.
Here opposite party, I want to withdraw my power, my lord.
So you want to withdraw your power?
Yes, ma'am.
All right. But he also wants an adjournment. First, let me pass that on.
Yes.
A prayer for adjournment is made on behalf of Sri S.K. Dwivedi on the ground of bereavement in his family. Sri K.K. Jana, Learned Counsel, appearing for the opposite party.
Yes, ma'am.
Opposite party has filed a memo withdrawing his appearance. The name of Sri Jana be deleted. Office to ascertain if any other counsel has appeared for the opposite party.
The other two, my lord, I have filed the case for withdrawal of the case.
Just list this matter on. See, 8 August or so. 28 June. Are they permitted to withdraw?
83 and 84.
Yes, yes.
Item 30. Pardon, my lord. 16 intermediate to continue.
Intermediate to
Item 30.
29 कौन लगी? Oh, 29 दी रहा है. Item 30.
May I please your lordship? My lord, all the petitioners are surrender and release on bail except petitioner number 9. My lord, I pray for 4 weeks time to surrender and
2 weeks further time is allowed.
31.
31. First time it has come.
Yes, ma'am.
2 weeks.
Passover.
Passover है ना ही विशेष.
Passover item 15.
Passover item 15. All right. We'll take it up then after recess. After that 2 p.m. that Mr. Nair will argue that matter.
ED matter.
ED matter. I think the other side is who is the other side? I think Mr. Gopal Agarwal. Yes.
Serial 4 in the weekly list. जोटा काली हेतला पास आउट फॉर द आई प्रे दैट नेक्स्ट वीक माय लॉर्ड काने सेकंड हाफ रे सान करटी रही आई ऑलरेडी इन्फॉर्म मिस्टर भुइया ही इज फॉर द अपीलेंट आई एम फॉर द प्रिंसिपल रेस्पोंडेंट नंबर 1
let it come up माने ये बैठे माने आफ्टर रिसेस आसो देखिए
आई
I don't make a mention, my lord. Weekly item 9, my lord. I pray one time may kindly be granted. I am for the appellant, my lord.
No, let it report out after recess, then I'll go through the brief and I will see. Not now.
Weekly
So, and my learned friend appearing for the other side, learned senior, Mr. S.P. Mishra, made a mention before your lordship in the first hour, not to take up this matter, whether I will wait or, and I
This
told.
is practically, I think, he has completed almost your arguments.
He has started.
I'm only warming up now.
If your warming up takes up 1.5 hours, then
We have to place some judgments today.
it's all right. It's all right. So, what do you say? You want an adjournment?
No, Mr. Mishra wanted an adjournment because he is suffering from some sore throat.
All right. So, the item kete? What is the
Item 4.
Item 4 of the weekly list.
Weekly list.
Take it next week. We'll take it up next week. I think did the hearing start in that case?
No.
Then we'll take it up on 13th.
Mila.
Does this matter in the week commencing 13th May? Okay.
Interim order to continue.
Interim order to continue. Yes.
Item number 29.
Please.
Pardon to make a mention, item 9 weekly list, my lord. May kindly be granted 1 week time, my lord.
Item?
9. It will be fresh admission matter, fresh admission, my lord. I pray 1 week time.
Item 9 All right. Let this matter in the week commencing 13th May.
Obliged.
All right, begin.
Please. I had broadly indicated 2 aspects, my lord, on this aspect of retrospectivity. One is, my lord, that some of these offenses were not originally in the statute and have come at subsequent points of time. And my lord, therefore, my lord, what is the consequence as far as a prosecution is concerned, where the events are prior to the inclusion? Because there can be 2 sets of cases. They can be those where the predicate of.
Yes, I got it. All right. Yes, please.
Because there could be two situations where the predicate offense takes place and in some cases may be concluded also prior to the coming into force of the PMLA Act, which is effectively 2005, though it was enacted in 2002. Or, my lord, where the predicate offense is prior to the inclusion in the schedule. Now, just for a point of completeness, my lord, I just want to hand over those relevant amendments. From the other side also. The statutes, just to show, my lords, that sequence in what manner, my lord, this took place. I just handed over, my lord, a compilation.
Yes.
Now, Lord, the first one is the act as it. I not obviously put the whole thing, Lords, only just the relevant parts, my lord. The first one, my lords, is the act as it was originally enacted in 2002. And on page 2, your lordships will get the original schedule.
Yes.
Now, in part A, paragraph 1, IPC only has 121 and 121 capital A. There is no 120B. In part B, because their part B has a threshold, there are again some IPC offenses, but there is no 120B. Then if you
Section 13 of the PC Act.
didn't exist at all in the schedule.
Yes, yes. On the
So
paragraph
right
8.
at the end, my lord.
Paragraph 8.
Paragraph 8.
Yes.
7, 8, 9, 10, 13.
Yes, I got it.
Please, I'm grateful. So I just want to give your lordship the legislative history because, as I pointed out, just kindly make a note that the period in question in this case is 31/7/1990, which is when the alleged illegal mining has taken place.
Yes.
To 31/7/2009. So, my lord, these two broad facts to be kept, my lords, in the background. This legislative history and this period.
So on the face of it,
yes, my lord,
you seem to be covered by the 2009 amendment. Are you not?
2009, my lord, which comes into some part, But my lords, as I will point out, my lord, also in addition, my lord, the lordships will note that the charge sheet is of course filed in 2000, much later, my lord, and then of course the PMLA is in 8 years later, my lord, in 2021. What will have some significance, my lord, and that's why I want to place those judgments. Lord, the judgments are, I just summarize, are broadly in 3 strands. Because as I pointed out on the last occasion, though this contention is squarely raised in Vijay Madan Lal, it is not answered. In para 65, 3 contentions are raised as far as retrospectivity is concerned. One is instances where offenses are concluded prior to the act.
Yes.
Second is where offenses are prior to insertion in the schedule. And third, which does not concern us, that there was an argument also on whether the explanation to section 3 is prospective or not. I am not getting into that. I am only on first and second. That is not answered except to the limited extent whatever answer is available in paragraph 270 of Vijay Madan Lal. Even in the concluding portion of the judgment, is 467? I think it's para 467, my lords, where the court summarizes its conclusions. There is no mention, my lords, of how this aspect of retrospectivity is dealt with at all. Therefore, my lords, it's my submission that Vijay Madan Lal on this aspect, apart from whatever light para 270 throws, doesn't really take us anywhere. What, my lords, I have been able to find and I wish to place before your lordships, Lord, there are several judgments of various high courts, my lords, on this. Most of them, to my mind, my lords, subject to correction by my learned friend, are all pre-Vijay Madan, may call it that, says is that even though there may be the date of insertion in the schedule is not relevant, even though the date in the schedule, the date of the scheduled offense is not relevant, what is relevant is there an offense of money laundering and on what date is that? Because that is what the relevant date is. And it is my endeavor on facts to show, my lord, that if I read the complaint as it is, there is nothing to show, my lord, that when the offense of money laundering has taken place after 2009. Yes. And on that score, my lords, according to me, my lord, in my respectful submission, even in the alternative submission, my case is likely to, my lords, succeed. If I may just hand over, my lords, I prepared a compilation. Manual. But first in line is Tech Mahindra. Because I will just because it's a very bulky compilation, I will broadly follow the pattern. Lords, I will show your lordships when the predicate offense is, when is the PMLA, and what is the contention and the finding.
Yes.
Lords, Tech Mahindra, if your lordships will just have the first one, para 1. On 7/1/2009, Ramlinga Raju, the chairman of Satyam, made startling revelations about illegalities in SSL, which triggered panic buttons among investors and employees in the corporate world. Crime number 2 of 9 was registered by the State Crime Investigation Department against the then chairman, directors and auditors. By order dated 13/2/2009, Government of AP entrusted crime investigation to CBI. Government of India also passed appropriate orders. Accordingly, CBI investigated into the crime and filed charge sheet in CC so-and-so, that's of 2010, in the file of so-and-so. The Directorate of Enforcement, Government of India registered ECIR on 23/1/2009 took up investigation. Consequent upon to the said investigation, Director of Enforcement filed complaint 2014 before the magistrate, etc. Court has taken cognizance of the same by order dated 25/2/2014. Now let's kindly come to page 4, para 12. Alternatively, it is contended that by senior counsel that even assuming that the petitioner is responsible for all the illegalities committed, because this was the case, my lord, the Tech Mahindra pursuant, my lord, they took over the business of Satyam. Is responsible for all the illegalities committed by the management of SCSL. Those alleged illegalities were committed prior to 2009. Allegation of offense of money laundering is only with respect to scheduled offense, as can be seen from section 3 read with 2U and 2Y. Petitioner company has not committed any forgery and therefore said provision is not attracted insofar as petitioner is concerned. In the charge sheet now filed, the provisions which are introduced into the schedule by virtue of Amendment Act 2009 are invoked, and thereby the petitioner is alleged to have violated the provisions of 120B, 419, 420, 467 and 471 IPC. Then those various sections are summarized, my lord. The 4 lines after that. Learned senior counsel therefore contends that initiation and continuation of criminal prosecution against petitioner is unsustainable and amounts to arbitrary exercise of power without jurisdiction and competence, and therefore liable to be set aside. It amounts to applying penal provisions retrospectively. Article 20, Clause 1 prohibits even formulation of charge with respect to an incident when such incident act is not classified as crime. Petitioner company is not concerned with forgery and the former management is accused of forgery. Petitioner company is not alleged to have any knowledge of the offense of money laundering, whereas primary ingredient of section 3 is knowledge, and therefore the proceedings against petitioner are ex facie illegal. Then, my lords, may kindly have, my lord, again at page 22, para 65.
Yes.
7 only insofar as the petitioner is concerned. In terms thereof, it thus means that to attract section 3, only allegation that we leveled was forgery of valuable securities will authority to receive any money by SCSSL. Then, my lords, judgments are cited. And finally, on the next page at para 70, it is well settled principle of law that no person can be prosecuted on the allegation which occurred earlier by applying the provision of law which has come into force after the alleged incident. In other words, there can be no retrospective application of criminal liability for the incident occurred prior to introduction of such liability in the statute book. Admittedly, prior to Amendment Act 2009, none of the provisions which are now invoked by the Enforcement Directorate were on the statute book except 467 IPC. Thus, the petitioner cannot be prosecuted by invoking those provisions. So, my lords, that is the clear view, my lord, that the court has looked at the date of insertion in the schedule, finds that the offences that are in the predicate offence were not in the schedule on the relevant date, and therefore says, my lord, proceedings cannot continue. Just incidentally, your lordships may note that SLP against this order was dismissed, and that order is at page 87. In fact, many of these orders, I'll be candid, my lord. Some of these are pending in appeal, some stay has been granted, some stay has not been granted. And I'm told, my lord, all these matters on this question of retrospective application are all now directed to be listed for final hearing in the Supreme Court on 23rd July, my lord. They have fixed 3 days, special 3-judge benches, they have not to decide this issue once and for all, because even in Vijay Madan Lal Chaudhary, in Karti Chidambaram's review petition, this, my lord, the issue has been squarely raised. So presumably, my lords, all this will be decided at some point, my lords, in the Supreme
Court. But if that is your submission, can this court enter into this controversy at this stage?
Lord,
the Supreme Court is in session over the matter.
There are 2 ways of looking at it. One is your lordship may say, I want to defer and await. The other approach could be, which is the approach, my lords, I'll show the judgment is here in Prakash Industries, that similar plea was raised before the Delhi High Court when Vijay Madan Lal was pending. And the Union of India, the ED, said that don't hear these matters because await the reference. And for whatever reason, which I can point out, the court said, I am not going to wait for the reference to be decided. That, my lords, is entirely your lordship's prerogative, my lord. I will not say one way or the other. If your lordship feels, my lord, that judicial deference, my lords, is that your lordship would like to wait for the orders of the Supreme Court, I have no difficulty with that.
That is actually, in a way, we are talking of judicial discipline also.
Correct.
When the higher court is in session over the matter,
Certainly, my lord.
it is always better to
I
wait.
can cite judgments that say it's not necessary, but I don't want to, my lords, I don't want to press the court on that. If it's your lordship's, my lords, view that it would be more appropriate to await, I have, my lords, I have nothing to say on that, my lords. I will not insist, my lord, that your lordship must hear and decide this. I just want to indicate, my lords, as a matter of...
No, you have been very fair in your submission by saying so, but then we'll have to take a call here.
So I leave that to your lordship, because some of the judgments which I'm relying on in this compilation are subject matter of those appeals. In some, there are some interim orders, some there are no interim orders. All that I'll place. I've come with all that. But I just want to indicate, my lord, that 23rd to 25th of July, they have kept these matters to be heard, my lord. And one of the aspects, of course, is this question of, they may decide other issues also, of course. But retrospectivity, I'm told, is one of the issues, because in
that seems to be a main plank of argument.
Yes, that's the primary. Secondary argument is, my lord, because of that interim order and the predicate offense, what flows? There are two judgments of one of the Telangana High Court and one of an interim order of the Delhi High Court, which has taken the view that if there is some kind of restraint in the predicate offense proceedings, then why should these proceedings continue? That's a second submission, my lord. That's a second submission.
So then we have to now decide whether we are should we proceed or not.
But I'm entirely in your lordship's hand, my lord. As I said, I can show you the reasons. If you don't want to proceed, the reasons are here in one judgment. But if your lordship's...
This is basically to, not just a question of deference, but also a question of, arriving at a situation where there's a possibility of conflicting orders being passed. I'll pass a particular order that may not be, why, if there is a chance, why not? But then what is your view, Mr. Agarwal?
It's up to my lords, my lord, whether your lord.
My friend is also very fair.
No, both of you are fair. There's no question of your doubting your fairness. But then should we keep it then pending?
I have no difficulty. But as long as my friend's courtesies will continue, my lord, till then. That is my concern.
No, that I think we can.
No, of course, no. My friends, your lordships have recorded. My friend has been very fair. I just want that arrangement to continue, nothing else.
Yes, what do you say? Since the Supreme Court is pending, and in this particular aspect, this is retrospectivity.
Yes,
I'll leave it to, yes, Mr. Nayyar, as you have very rightly said, it may be open to the court to take a call here, but then the traditional view would be to,
I don't want to, my lords. As I said, I don't, it is not.
This is actually more, strictly enforced when it's a question of 227, because the High Court and the lower courts.
Correct.
So they will not touch it. And they're not supposed to touch it also. But insofar as superior courts are concerned, it is always open. Open, but then as a matter of, prudence, and also as a, we normally leave it.
Yes.
उनको decide करने दीजिए.
That I can't say.
हम क्यों उसमें घुसे? वो decide करें.
I am deprived of the pleasure of addressing your lordship for the.
I will also be deprived of the pleasure of hearing you. Then
all I can say for myself, my lord, that for me, my friend, of course, I'm sure is familiar with all this, but for me, it has been a great education. We have to actually find all this. And
I think, but these are all new sides of law, which we are not very thorough. I must also, confess that prior to elevation, I didn't even hear about the, what do you call that PMLA Act. I didn't have any occasion to hear about it.
It also became active after the 2019 amendments. 19 amendments.
And Mr. Agarwal has been educating me.
After 2018, Lord.
18, 19.
He has been educating me. So should we leave it at that?
I'm in your lordship's hand, but I have no difficulty.
What do you say? All right. In course of hearing, Sri Nikhil Nayyar, learned senior counsel appearing for the petitioner, submits that the matter relating to retrospectivity of
lordship may say inter alia, because they
that I will say. The matter relating to retrospectivity is pending adjudication before the Supreme Court along with related issues. along with related and incidental issues. In such view of the matter, this court feels that it would be proper to, and further, he further submits that said matters are likely to be listed before the Supreme Court in the second
23rd July. There is an order
on 23rd July. Stop. Such being the submission, this court deems it proper to wait for a decision by the Supreme Court in the said cases. Stop. Then what was the arrangement?
Just Lordship will see para 5 of your Lordship's last order, which reproduces the earlier order, but para 5 is good enough for me.
Para 5
of your Lordship's last order.
As indicated in order dated 16/2. Till such time, similar arrangement as indicated in order dated 16/2/2024 at paragraph 3 shall continue. What was it? That was Justice S.S. Mishra had passed that order.
Correct. Correct.
We make an application with
Someone was issued to participate in the investigation.
He may move an application.
If he is unable to go, he will move an application.
Because I don't want any precipitate action, my lord, said while I'm here. Event should not overtake me, my lord.
It's all. It has heard in part. All right. So we'll see then.
Then would your Lordship want us to mention it, or Lordship will keep it for directions in August or something?
I don't know whether it all depends on whether it is of my assignment or not.
No, that will remain with the Lordship because as a Lordship
assigned to my
that's assigned to a Lordship. So that will remain with your Lordship.
Then you make a mention. Make a mention.
The Lordship may say liberty to mention.
Yes, yes. It shall be open to the counsel for the petitioner to make a mention for listing of the case upon disposal of the case before the Supreme Court.
Okay. Very good. I am very grateful.
So I had cleaned my board today to hear you.
I'm sorry, my lord.
To hear you and of course,
Mr. Agarwal.
Mr. Agarwal.
No, I just thought I should indicate.
No, it's very, very fair, very fair.
Because Obalapuram, which I wanted to rely on, is the lead matter in the reference. And Obalapuram was straightforward, similar like what I've shown. They said it's a very short judgment, division bench of Karnataka High Court. And the court said because it's prior, and again a mining case, it's prior, the act was not there, and they quashed the whole thing. But Obalapuram leave was granted, and in fact, while granting leave, Supreme Court said will not be treated as a precedent. But that is the lead matter.
No, but here, one thing that strikes my mind is that you see, part of the offences are included. You say the check period is 31/7/1990 to 31/7/2009.
Perhaps 4 months.
So for that 4-month period.
But then there's an argument on fact to be made on that, my lord.
True.
Yes, there's an argument on fact to be made on the basis of the complaint.
So simply by saying that they are not covered because they are beyond or prior to the 2009 amendment,
correct,
probably may not hold water in the sense that as your 2009 amendment came into force.
That is why the third strand, which I said, which is the nuanced approach, that will come to my aid.
Oh, whatever comes. Just keep it with you.
Very grateful.
Oh, thank you.
Obliged. I'm sorry, my lords, for upsetting your
No, absolutely not. It's always a pleasure to hear you.
Grateful.
So ask somebody to make a mention.
Yes, of course. Yes.
Item number 13.
I think other colleagues in the bar will be upset a lot because they must have thought that this matter will go.
We were under impression that this matter will continue.
They are all old second appeals. Naturally.
And even very low interest.
Yes, item 13. Next. Next week, okay. None appears. This matter in the week commencing 13th May. Yes. Item number 19. Oh, yesterday's matter.
Yes,
Are you ready with that map?
but the map, I called for the map from the client. He said he needs some time.
You should have prepared it yourself. Just to indicate to the court.
But I have prepared the date chart as per your lordship's.
Pass it on, but otherwise, you are saying that there was a road nearby. How will the court imagine? Unless you come forward with some.
There's a map attached to the.
Which is kind, sir, where is that?
Yes.
Where is it? Is LCR Archie? Is it there in the LCR?
Yes.
All right. Let me open the LCR.
Because the only thing is that the map I could not understand much, which is why I sought for his assistance. He said, "Got a week to I'm going to so that is how."
See, map ta kothre achi?
Map sir, should I just forward my copy so that to save time? So this is attached to the judgment.
Judgment?
Yes, my lord. Exhibit 1.
The problem is the scanning, the what do you call the metadata entry is very, very poor.
Very.
Because they don't understand what is what.
Yes. The photocopy of the LCR that comes through is.
It's not a photocopy, it's a scanned record.
It's a scan.
It is completely scanned. And there's a metadata. We are searching it because of the metadata. The metadata is entry column say the quota. And somebody having no legal knowledge will always be in a quandary. Anyway, yesterday, what was your submission?
There's a summit of minutes. Here, Milords, the plaintiff, the present appellant is the plaintiff. And a suit was filed to declare the sale deed filed executed by defendant number 2 in favor of defendant number 1 in the year 2013 as null and void. The reason for such prayer that was sought for was that in the year 97, there was an agreement between defendant number 2 and the plaintiff, wherein the plaintiff was allowed to use that suit land as a passage for ingress and egress to her residential plot. Now, let's the 2013 sale was by defendant number 2 in favor of D1. D2 is the owner. But the learned trial court decreed the suit, having regard to the fact that there is an agreement executed by D2 in favor of plaintiff, where the right in respect of that land has been granted to the plaintiff to use it as a passage. That is an easement by grant, and it decreed the suit. The decree was also based on the reasoning that D2 has not come forward and challenged that agreement. There was no challenge to the agreement, so it was accepted as such. D1, who is a non-party to such agreement, challenges the genuineness of the agreement, saying,
because he steps into the shoes of the defendant number 2.
Yes, but he is not the executant.
True.
So D2 has not contested. So obviously, D1 is not left with any option but to contest it herself and say that no, this document has not seen the light of the day. So the learned first appellate court reversed the judgment on the ground that that agreement is of the year 94. That is prior to the compromise between the parties in the form of a Faislanama, which was later on made the rule of the court. So that Faislanama, when it was made rule of the court, this agreement between the defendant number 2 and plaintiff was existing. That was not brought to the knowledge of the court, which was making their award as a rule of the court. So it is not to be relied upon. I read out that paragraph before your lordship. There are some other grounds on which it was reversed as well. The others being, there is no relief prayed for setting for declaration of easementary right. That is number 1. Number 2 is that that plot was never used as a residential purpose. The plaintiff was only in possession after 2011 when there was a conversion of the land to homestead. And third is this part, that the agreement doesn't bind the purchaser. Now, Lords, I respectfully submitted before your lordship that 97 agreement is not 94 but 97. So therefore, that finding is vitiated altogether in toto. The fact that no prayer in respect of declaration of easementary right is concerned, since that document of 97 is not in dispute, the defendant number 2, who is the executant and the owner of the land, has not challenged it. He has not come forward to say that it is not the document executed by him. Rather, as a witness to defendant number one, he has accepted his signature. So that is what my humble submission was. And therefore, I humbly submitted that no such prayer was required. Rather, it was the onus was on the defendant number one to seek for cancellation of that document, because in the absence of cancellation, the document has seen the light of the day, it has been acted upon, and a grant has been created in favor of the plaintiff for the purposes of using it for perpetual purposes. But so far as the initial point was concerned, that there was an agreement, which is why your lordship wanted that schedule map, my lords. Lords, the case of the plaintiff is that this defendant number two was in possession of a certain property, which was also in occupation of the boundary tenants as well as the plaintiff, including the D1. There was disturbances, which is why there was a requirement of a compromise. Now, a compromise was arrived at in several Panchayat Faislanamas, wherein the defendant number two unequivocally relinquished his share over the property and granted it in favor of the boundary tenants, including D1 and plaintiff. Well, this is way back in the year 1990. Now, that Faislanama was later on made rule of the court in specific awards, specific judgments and decrees. There is a schedule map attached to each of these judgments. In the schedule of map, this particular suit, schedule B property in the present suit, was shown as a road, as a Gharoi Rasta. D1 accepts it, but naturally, because he has not challenged it. He raises a question as to whether inclusion of such a plot in the schedule of an award, which did not concern the said land, can be accepted to be binding at this stage, which is why your lordship wanted to see that schedule. Your lordship will kindly just, let's have said so many things, the date chart will clarify. Sorry. This is a short date chart, but only relevant dates. 23/9/94, the plaintiff got an award in her favor in the title suit number 160 of 94, wherein the suit schedule B property has been shown as a road over plot number 426. Decree passed in TS number 429 of 95, filed by D1, declaring her right title interest with respect to area 0.020 decimals under HAL plot number 426, HAL Khata number 235 of Mauza Paisa, Katak Sahar, unit number 28, corresponding to so and so, wherein the suit schedule B property was also described as road meant for defendant number one and plaintiff. 19/3/97, an agreement was executed between the plaintiff and defendant number two, the original owner, with respect to the schedule B property, wherein right of easement of way was given to the plaintiff by defendant number two. 5/1/2013, defendant number two alienated suit schedule B property in favor of defendant number one by RSD number 121. 24/6/2017, cause of action for suit arose when the right of the plaintiff in the use of schedule B property was invaded upon and obstructed, and when defendant number one stacked the building materials over the said land, and FIR to that effect was lodged before the local police. But thereafter the formal orders, formal dates. But what your lordship will kindly see is that by virtue of this agreement on 19/3/1997, an easement of grant was executed by defendant number two in favor of the plaintiff. Now, lords, one question that I asked myself while preparing for your lordship's assistance yesterday, is that whether a subsequent sale deed, but your lordship will kindly consider, the defendant number two continues to be the owner. In spite of the easement of grant, he continues to be the owner over the respect of the property. So whether at a later stage, he can exercise right over the property and sell the property to someone else, including the grant executed in favor of a particular person, in this case, the plaintiff. Now, as the Supreme Court in more recent times has held that is Section 48 of the Transfer of Property Act. Well, may I just take your lordships to that part? Section 48.
Yes.
But priority of rights created by transfer, where a person purports to, it's very ambiguous provision, so I'll read slowly for your lordship's brevity, my lord. Where a person purports to create by transfer at different times rights in or over the same immovable property, and such rights cannot all exist or be exercised to their full extent together, each later created right shall, in the absence of a special contract or reservation binding the earlier transferees, be subject to the rights previously created. So notice what my humble submission is, that by virtue of the grant in 97 and in the absence of the 2013 sale deed dealing with such a grant, the subsequent transferee is bound by the grant. So it satisfies my query. So far as I am concerned, I need to also assist your lordship in that. It satisfies my query that he could have, in a manner prescribed under law. That has not been done. In the 2013 sale deed, my lord, nowhere has it been mentioned that the grant which was executed in favor of the plaintiff either merges with the sale deed or is extinguished. Your lordship will kindly appreciate, easement by grant is not like easement by necessity. But easement by necessity will terminate upon the termination of the necessity. Your lordship will kindly see section 41 of the Easements Act.
Read it out.
Well, extinction and termination of necessity. An easement of necessity is extinguished when the necessity comes to an end. It's a simple provision. So, had it been a necessity, then the alternate road exists now. So, my easement by necessity, would have come to an end. But this is an easement by grant. Grant has not been cancelled. Grant has not been recalled by way of an agreement or any written instrument. So, it continues. So, when D2 has not revoked that grant expressly or impliedly, a sale deed cannot be executed, especially in terms of section 48. I just read it out. So therefore, this 97 document is of great value. However, the other ground taken by the defendants was, and also by the learned appellate court, is that this 97 has been written in some places in the plaint as 94. However, I'll file those compendiums along with my note, that where there is a discrepancy between the plaint averments and the list of documents, the evidence is to be gone into. And with the evidence is 97, in which case, this case, the evidence is 97, then the documents will prevail. So because my averments may be suffering from typographical errors, but when the document are placed on record and the evidence led is on the basis of 97, the learned appellate court could not have gone to, in fact, it has not gone to, that was my learned senior's submission. The learned appellate court has proceeded on the premise that the document is executed in 94. The judgment doesn't say that the plaintiff mentions the document to be 94. Matter would have been different if that was the case. He has referred to the document, has construed the document to be executed in 94, which is not correct. That is where I say that that finding is vitiated in total. But the only thing that, in fact, remains is that schedule map, and which I bow down that your lordship has to. If you
were showing me some copy.
Yes, yes, my lord. This copy is there. But this, let's if I'm
just to have a feel of it.
Yes, yes, my lord. I have also paginated the exhibits. My lord, this is way too ambiguous for your lordship's lord's meaningful consideration.
That is why I would like you to prepare a map.
I completely.
And if necessary, by highlighting it through different highlighters.
I'll do that.
Different colors.
I'll install some.
Plot number 4.
426 is a huge plot.
But how?
The 426, so far as 20 decimals is concerned, the defendant number 2 has relinquished in favor of defendant number 1. Now, the defendant number 1 says that she uses. It's very important, my lords. Yesterday I pointed out from the judgment. If the need arises, I can show your lordship again. the defendant number 1 has categorically stated in the evidence that he or she, my lords, I'm not sure, is using that plot of 7 Kadi 6. But the passage is, it's hardly discernible, my lords, that is the difficulty.
Is it L2? So something you have mentioned as L2.
Plus that,
Where is it?
he explained to me, but it is a little difficult to discern.
Yes, we'll, today, after you complete, we'll hear, I'll hear Mr. Mishra, and thereafter, if necessary, I'll keep it to next week.
Yes, yes.
I was intending to close it.
Complete it, my lords, today.
But then without the map, probably, what you see, it's a human nature again.
Yes.
Whatever you are submitting with regard to a particular road or a lane or a passage being treated as easement, then the court can only imagine. So something must be there on record. So have you completed today, or you have?
A little bit is left.
Please
The
continue.
only thing which I wanted to point out is that that passage is now being used by the D1 to access her plot. Lords, your lordship will appreciate. I just read out from the date chart. There was a suit filed by D1 against D2 to claim that 20 decimals of land, which he has been in possession for more than 12 years. D2 entered into a compromise and said that, all right, you use that property. This is yours. I have extinguished my right. That compromise was made rule of the court. In the evidence in the suit, D1 has admitted in evidence that he is using that patch of land as a road. The evidence is there. So the difficulty in envisaging that the road is used as a Gharoy Rasta is not left to any dispute. Secondly, the finding of the learned appellate court that the plot only came to be converted to a homestead land in the year 2011 or 12 something. So therefore, Gharoy Rasta at the time when the suit was decreed could not have come through.
No, but then the Faisalanama, which ultimately became the rule of the court, was not not in relation to that
plot.
I mean the easement.
Easement, right?
So you are using it for collateral purpose.
Yes,
isn't it?
Yes, brother.
You are using that Panchayatnama, Faisalanama rather.
Panchayatnama also,
which has also become a rule of the court according to you, and that you are using it for collateral purpose.
Collateral purpose, because where that property was demarcated, this property was demarcated as Gharoy Rasta.
But then thereafter, it is only after that Faisalanama became a rule of the court that this agreement or that sale was.
Yes. Agreement of grant.
Grant was given.
The grant of easement. Yes, brother. But what I mean to, it's a fine line here, my lords. I just wanted to bring it to your lordship's knowledge. But likewise, like the defendant number 1 and D2 got into a Faisalanama, the plaintiff and D2 also got into a Faisalanama in respect of Schedule A property. But here we are concerned with Schedule B. Schedule A is the property of the plaintiff as per the compromise between plaintiff and D2. Even in that Faisalanama, my lords, which was later on made rule of the court, there it was shown that road was shown as the Gharoy Rasta. What I humbly beg to submit here, my lords, the learned appellate court has disputed the utilization of that plot, Schedule A property, as my homestead land, saying that it was only converted in the year 2011. So there could have been no Ghara prior to 2011 for the purposes of that Rasta being used as a Gharoy Rasta. But it's completely ignoring the fact that there was a compromise where there was a house of the plaintiff that was used by the plaintiff notes. That property which originally belonged to the D2, they got into a compromise. And plaintiff was residing there. That is the judgment that he has been, the plaintiff is in possession, and being in possession for more than the statutory period, the defendant number 2 has given up his right. Accordingly, it was made rule of the court. So when that judgment is there in respect of Schedule A property, merely because the land got converted to homestead much later, the factum regarding plaintiff using it as a homestead land cannot be disputed. Your lordship knows the regularization may take time, so far as conversion is concerned, my lord, under Section 8A of the OLR Act. But when there is evidence on record to show that she was using it as a residential house, disputing the Gharoy Rasta on the ground that there was no Ghara over the Schedule A property, but my humble submission is not correct. So this is broadly what I submitted yesterday also, just recapitulated.
Yes, Mr. Mishra.
Let us first read the civil suit. Or may kindly have a glance to this
and the plaint.
plant of the suit.
ये जो କରିଛନ୍ତି scanning, it's very difficult to find out. I'm thinking of directing the register judicial to again hold a training of these people. They don't, because they are not legally trained persons, these scanners. Let me just find out. দেখুন সেটা কোন কোউ হেডিং এর হইছি না অ্যাড্রেস স্টেটমেন্ট অফ দ্য প্ল্যান্টিভ
Address statement of
শুনুন 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 আপনি বুঝি পাইলেন এখানে মেটাডাটা রে এন্ট্রি হইছে অ্যাড্রেস স্টেটমেন্ট অফ দ্য প্ল্যান্টিভ সো হাউ উইল ইউ নো at a glance that this is the plaintiff they are referring to address statement of the plaintiff to first page লেখা যায় সেটা বানিয়ে দিচ্ছেন তো
কপি করে দিলে
সেটা বানিয়ে দিচ্ছেন তো metadata entry is very important anyway all right so
para 2 to
para 2 yes
that the suit land described in Schedule A to the plan comprising of an area of 70 decimals was recorded in the name of plaintiff by virtue of the order passed by mutation case number 1307 of 96. In order to change the kisama of the said land, the plaintiff preferred an application before the land Tahsildar Sadar Cutoff under section 8A of the OLR Act by OLR miscase number 282 of 2011, pursuant to which the kisama of the land was converted into Ghoravari, whereafter the plaintiff constructed his residential house over the same and continued to stay there without any dispute from any corner whatsoever. So this is important. After conversion of that land into Ghoravari or homestead, she was staying in that plot after constructing the house. It is their pleadings and assertion. Now, Lordship may see para 5. That agreement which was there for placing that grant was given.
Para 5.
Para 5. That consequent upon the award made by the arbitrator, which subsequently was made rule of the court, inter alia giving an absolute right to the plaintiff over the Schedule A property as well as Schedule B property, which is within the knowledge of both the defendants. It is stated that an unregistered agreement was also executed between the plaintiff and the defendant number 1 on 1994 with respect to B schedule property, wherein the right of easement of way was given to the plaintiff by defendant number 2. It is their assertions and it is also there in the pleadings. That is not once, then Lordship may see this has been repeated in para 8 and para 10.
Yes.
Yes. So Lordship may see in the middle portion. Though the said defendant 2 has no alienable right to execute the said sale deed in favor of defendant 1, ignoring the right given to the plaintiff and other person depending upon the said road in and around the year 94. Now again in the same thing is repeated in para 10. That the plaintiff begs to submit that by transferring the right in favor of the plaintiff in and around the year 94, by executing an agreement to use the Schedule B property as a road, the defendant number 2 has lost all its right, including the alienable right over the said portion of the land. Now, Lordship may see the prayer. He is not the co-owner or co-shareholder of the defendant number 2. He is a stranger to the property. His right to the property accrued after the Panchayat Faisala with respect to Schedule A land. Now here he is claiming B schedule land. Entire suit is based on B schedule land. That he wants to cancel the sale deed. How he has the right to cancel the sale deed without any prayer with respect to his better right? Can it be maintainable? It is not maintainable under section 34 of the Easement Act. Now, specific relief act. If there is further prayer is to be made, then it independently this particular prayer is not maintainable. Where he has made the prayer to cancel the sale deed and as well as to get a permanent injunction with respect to B schedule property. Defendant number 2 is the owner of the land. He can sell the land in favor of defendant number 1.
He has not given the land, B schedule land to the plaintiff for easement right. Later on, we will see the agreement that which my learned friend is placing. What has been given there and that has not been proved also.
Correct.
That is an unregistered agreement that has not been proved. No attesting witness is there, and also the plaintiff himself in the cross examination admitted that I do not know anything about the Exhibit 3, that agreement. And we are not using Schedule B as a road. The land attached to a scheduled land in the western side, that has been given by defendant number 2 in this said agreement. That is Exhibit 3, not the B scheduled property. A grantor cannot at the same time give the 2 lands for the easement right. What has been written, I will place that entire fact. Now, what is the prayer? That the decree be passed declaring that the sale deed number 122 dated 5/1/13 executed by the defendant number 2 in favor of defendant number 1 is illegal, void, inoperative, and not binding on the plaintiff, and it be further declared that no right is accrued to the defendant number 1 by virtue of the said sale deed. Let the defendant number, more particularly the defendant number 1, be permanently restrained from creating any disturbance over B scheduled property in any manner, and also restrain, obstruct the use of the plaintiff over the same, and also from making any forcible with respect to that grant, and also that he has not made any prayer with respect to declaration of easement right with respect to B scheduled land. Only cancellation of sale deed independently has made this prayer. That is not maintainable without the prayer for easement right. Now, this suit is also barred by law of limitation. When the sale deed was executed, that is 5/1/13. That is cancellation of agreement within 3 years. He has filed the suit on 17/7/2017. That is in the WS also we have stated that it is barred by law of limitation. That the trial court has not framed any issue with respect to easement right. Incidentally, the trial court has dealt with that easement right while considering the issues with respect to the issue number
You're looking at trial court judgment.
4, 5, and 6.
You're looking at the trial court judgment.
Yes, trial court judgment, what means the issues framed.
Yes.
There is no issue with respect to easement right. Whether there is any cause of action on the part of the plaintiff to file the present suit, whether the sale deed bearing 1 permanently for causing any disturbances over B scheduled property, whether the plaintiff are entitled to cost of the suit, whether the plaintiffs are entitled to any other relief. So there is no issue with respect to easement right. Now, Lordship may see the judgment at page 45, trial court judgment. It has given the definition of what is the easement of
you say about what is the internal page?
Internal page of 11 of the judgment.
11. Yes.
Yes, I am placing. Since the plaintiff claims the right of way over the B scheduled land, which is the essence of her claim, an easement is defined as privilege without profit, which the owner of one tenement has a right to enjoy in respect of that tenement in or over the tenement or another person by reason thereof. The latter is obliged to suffer or refrain to doing something on his own tenement for the advantage of the former. It also said to be the right which person has to use the land of another for the specific purpose, not inconsistent with a general property in the owner or as a servitude imposed on a burden of land. Prescriptive period cannot in ordinary circumstances maintain an action to prevent a stranger from obstructing him using the way such an action can only be maintained where the obstruction to use has the effect of substantially depriving the person using the way of enjoyment of his property. What then a plaintiff is to prove is that there has been an actual enjoyment has been peaceable, that the enjoyment has been as of right, that it has been enjoyment as an easement, that it has been enjoyed without interruption, and that it has been enjoyed for 20 years. Unless these ingredients are proved, no right of easement can accrue to the owner of a dominant heritage. Here there is nothing else stated about the grant of easement. These are the definition of that the easement of prescription and easement of necessity. Thereafter, the court decided in my matter on the basis of four that is suits which are disposed of basing on the Panchayat Faisala. Lordship may see the decision next para. In this regard, on going through the evidence of the parties as well as on specific perusal of the judgment passed by the court, Exhibit 1, 2, 8 and 9 in favor of Sanjukta Sai, Kusuma Manjari Rana, Raghunath Sao and Judhishthra Vasa, it is found that the heat schedule B land is reflected as a road in the sketch map attached to the judgment. The defendant number 1 also admitted the content of all judgments as true. She has also not challenged the findings of the court before any forum. In the said judgment also boundary description of the respective land is also mentioned where it is reflected as road both the eastern and western side of the plot. The defendant number 1 also admitted in his evidence that she has not constructed any house over the Schedule B land. Therefore, after going through the discussion made above, it is found that the road as mentioned in suit Schedule B land is used by the plaintiff as easemental right by way, right of way, for which the shall deed executed by defendant number 1 in favor of defendant number 2 in favor of defendant number 1 is void and illegal. 1 and not right is accrued to defendant number 1 by virtue of shall deed as the suit land use as the easemental right of way of the plaintiff, the defendant number 1 is restrained permanently from making any construction as well as obstruction over the suit Schedule B land. Accordingly, the issues are answered affirmatively. So nothing has been stated about the grant. Now, Lordship may see the suits, that 4 suits, which are mentioned by my learned friend. Panchayat Fasalanama, Lordship may see. First suit was filed by the plaintiff. Suit number 160 of 94 decided on 23/9/94, basing on the Panchayat Faisalanama.
No, not there.
Lordship got it?
No. LCR ଅଛି କି ଦେଖିଲ?
LCR ଆସିବ।
ଏକ୍ଜିବିଟ୍ ହେଇଥିବ ନା?
ହଁ, Exhibit 1,
ଏକ୍ଜିବିଟ୍ ଟାକୁ ନାହିଁ ଏଥିରେ।
Exhibit 1. These are all decided on adverse possession. This Panchayat Faisalanama. I am placing आम्बे प्रथम पक्ष पिताଙ୍କ ପଛରେ ପଡିଥିଲେ ଓ ଦ୍ୱିତୀୟ ପକ୍ଷ ଆଜକୁ ବହୁ ବର୍ଷ ହେଲା ପ୍ରଥମ ପକ୍ଷଙ୍କ ସତ୍ତ୍ୱ ବିରୁଦ୍ଧରେ ଦଖଲ କରି ଆସୁଛନ୍ତି। ଏଣୁ ପ୍ରଥମ ପକ୍ଷ ଉକ୍ତ ବୃତ୍ତିକୁ ତାଙ୍କ ନିଜ ଖାସ ଦଖଲକୁ ନେବାକୁ ଚାହାନ୍ତି। ଦ୍ୱିତୀୟ ପକ୍ଷ ଦାବି କରନ୍ତି ଯେ ଯଦିଓ ନିମ୍ନ ତଫସିଲ ବୃତ୍ତି ପ୍ରଥମ ପକ୍ଷଙ୍କର ଥିବାର ପ୍ରମାଣିତ ହୁଏ, ତଥାପି ଦ୍ୱିତୀୟ ପକ୍ଷ ନିମ୍ନ ତଫସିଲ ବୃତ୍ତି ସମସ୍ତଙ୍କ ଜ୍ଞାତସାରରେ ଉପରୋକ୍ତ ମତେ Lordship got it? I am placing that ଆଜକୁ ବହୁ ବର୍ଷ ହେବ ବିରୁଦ୍ଧ ସତ୍ତ୍ୱେ ଦଖଲ ଥାଇ ଆଇନ ଅନୁସାରେ 12 ବର୍ଷରୁ ଉର୍ଦ୍ଧ୍ୱ ଯଥେଷ୍ଟ ଉର୍ଦ୍ଧ୍ୱ ହବ ଅର୍ଥାତ୍ ଜମିଦାରୀ ଉଚ୍ଛେଦ ଆଇନ ପୂର୍ବରୁ ଉଭୟ ପକ୍ଷ ତାଙ୍କ ପିତାଙ୍କ ଅମଳରୁ ଦଖଲ କରୁଥିବାରୁ ସେ ତହିଁରେ ଆଡଭର୍ସ ପୋଜିସନ ଦ୍ୱାରା ନିଜ ସତ୍ତ୍ୱ ପାଇଅଛନ୍ତି ଅର୍ଥାତ୍ ପ୍ରଥମ ପକ୍ଷ କିମ୍ବା ତାଙ୍କର ପିତା ଆଜକୁ 40 ରୁ 41 ବର୍ଷରୁ ଉର୍ଦ୍ଧ୍ୱ ହେବ ଦଖଲକାର ନଥିଲେ କି ନାହାନ୍ତି। ଦ୍ୱିତୀୟ ପକ୍ଷ ନିମ୍ନ ତଫସିଲ ବୃତ୍ତିକୁ ପ୍ରଥମ ପକ୍ଷର ସତ୍ତ୍ୱ ବିରୁଦ୍ଧେ ସମସ୍ତଙ୍କ ଜ୍ଞାତ ସାରରେ ଦଖଲ କରି ଆଡଭାନ୍ସ ପୋଜିସନ ଦ୍ୱାରା ନିଜ ସତ୍ତ୍ୱ ପାଇଅଛନ୍ତି। So basing on this, that what is the extent of land that has been settled? Lordship may see that is in the ତଫସିଲ ସମ୍ପତ୍ତିର ବିବରଣୀ 70 decimil of land. ତଫସିଲ ବୃତ୍ତି କଟକ ଜିଲ୍ଲା ଅନ୍ତର୍ଗତ ପୋଲିସ ଷ୍ଟେସନ ଚାଉଳିଆଗଞ୍ଜ ରେଭିନ୍ୟୁ ଥାନା ସବ ରେଜିଷ୍ଟର ମୁକାମ କଟକ ସଦର ଇଲାକା ଜିନ ଶାବକ ନମ୍ବର 225 ନମ୍ବର ଥାନା ହାଲ ମୌଜା କଟକ ସହର ୟୁନିଟ 28 ପଇସା ରକବାରେ ଥିବା ହାଲ ପ୍ଲଟ ନମ୍ବର 200 ଖାତା ନମ୍ବର 235 ସ୍ଥିତ 424 ନମ୍ବର ଖସଡା ଖାତା ନମ୍ବର 235 ଖସଡା ନମ୍ବର 426 ପ୍ଲଟ ରକବା 70 ଡେସିମିଲ ଆୱାର୍ଡ ସହିତ ଦ୍ୟାଟ ବାଉଣ୍ଡରୀ ଲର୍ଡସିପ ମେ ସି ଦି ବାଉଣ୍ଡରୀ ଡେସ୍କ୍ରିପସନ ଯାହାର ଉତ୍ତରରେ ଚନ୍ଦ୍ରମଣି ବାରିକ ଲର୍ଡସିପ ଗଟ୍ ଇଟ୍
ବାଉଣ୍ଡରୀଟା କୋଉଠି ଅଛି ସେ ହଁ ଯାହାର ଉତ୍ତର ପଟେ ଚନ୍ଦ୍ରମଣି
ବାରିକ
ଦକ୍ଷିଣ ମହେନ୍ଦ୍ର ରେଖା
ପୂର୍ବରେ ଘରୋଇ ରାସ୍ତା that is B schedule land they are claiming. Boundary means that description identification of land that has been given through boundary description. That is nothing to do with the settlement of the land. 70 decimil of land has been settled, not 7 decimal 6 code. If in the eastern side there will be gold mine, that will be the plaintiff's property. No, boundary description is for the identification of the particular land. That does not describe the land, road, whatever available in the boundary.
That is why I asked him that he is using it for collateral purposes.
Yes. Lordship, boundary description is separate. He has given a 70 decimal of land through this Panchayat Faisalama to the plaintiff, not the B schedule land. Similarly, that second cell did all that suit that is 429 by 95. The defend number 1 got 20 decimal of land, and with respect to other two TS number 14 of 95, one Raghunath Sahu, that is exhibit 8. He has got 80 decimal of land, and TS number 491 of 2002, where the Judistra Vasa, he has got 55 of decimal of land. There is no description of a road in the boundary description. Lordship may see the other two source. Also attached to that particular
yes,
Panchayat Faisala, all Faisala number, that particular land has been given in the marks. What how তফসিলভুক্ত প্রপার্টি কটক অন্তর্গত স্টেট চাউলিয়াগঞ্জ লর্ডশিপ এনসি 235 নম্বর খাতা স্থিতিবান প্লট নম্বর 426 তন্মধ্যରୁ 22 ডেসিমিল প্লট নম্বর 427 তন্মধ্যରୁ 33 ডেসিমিল মোট 55 ডেসিমিল କୁ ଜମା 42 ଟଙ୍କା ଅଟେ। ଅତ୍ର ବୃତ୍ତି ଯାହାକି ଅତ୍ର ଆୱାର୍ଡ ସହିତ ଦାଖଲ କରୁଥିବା ଚୁମ୍ବକ ନକ୍ସାରେ ବି ଚିହ୍ନିତ ଅଟେ। ଏଥିରେ नो ବାଉଣ୍ଡରୀ ଡେସ୍କ୍ରିପସନ, ଓନ୍ଲି ମ୍ୟାପ ଇଜ ଆଟାଚ୍ ଲର୍ଡସିପ ମେ ସି। B schedule land has been given to that Yudhishthira Vasa, 55 decimal of land. So there is no description of boundary, that is, there is no road. That whatever land has been given by the defendant number 2, with respect to that Yudhishthira Vasa, that has been mentioned here. He has got 55 decimal of land. Now, Lordship may see the agreement, that particular agreement which my learned friend is placing. I am placing that agreement. What is there, what has been given, that has been never been proved. There is no attesting witness, and the plaintiff does not know about this. I will place their cross-examination, that is evidences. Now, Lordship may see. एक की शर्त एक की हमें दाता
केते एग्जिबिट केते
that is exhibit 3.
एग्जिबिट 3
Exhibit 3. एक ही आंबे दाता तपसिल लिखित पथ सत्व प्लॉट रे आज को बहुत दिन हम अर्थात आंब पितांकर पैतृक संपत्ति एका एक मालिक सत्वाधिकार थाई तफसिल सत्व को आज को बहुत दिन पूर्व जमी नहीं गरबारी वृत्ति दखलकार अछंती और जमी नेबार समय ग्रहिता मानकर चलाचल सुविधा पाई एक रास्ता मुख्य रास्ता ठारू ग्रहितांक घर और सदर दर्जा को लगी ग्रहिता मानकर चलाचल सुविधा पाई छाड़िथिलु वर्तमान से रास्तार रेकर्ड आम पिता को नाम रे इजिमेल अच्छी आंबर पिता तांकर अंश भरणा बाबद को बुढ़ा बापा और बुढ़ी मांकर सेवा शुश्रूषा आदि केते गुड़िए कार्य संपादन कर बुढ़ा बापा निज इच्छा तांकर स्व उपार्जित संपत्ति को आंबर पिता अनंत चरण साहू और खुड़ता रहीचंद्र साहू को दत्त करथिले तदनुसार पिता और खुड़ता दत्त संपत्ति को निज निज मध्य विभाग बंटन कर तफसिल संपत्ति को आंबर पिता कक्षरे एकाकी पाइथिले और यही तफसिल संपत्ति को आज सुधा ग्रहिता माने निज नाम रे सरकारी शिरस्तार रास्ता कमिशन किसम रेकर्ड कराई पारि नांती भविष्यत द्वंद्व निवारण रास्तार रेकर्ड कराइबा निमंते पथसत्व इजिमाली ग्रहिता सत्तर मालिकाना बाबदरे सांत्वनामूलक 18,000 टंका देई रेकर्ड कराइबा को चाहिबारु आंबे दाता एकमत होई एथि सहित सामिल थिबा इजिमाली पथसत्वर एकमत होई एक चुंबक नक्शा और चिरस्थायी नानादी पत्र संलग्न कराई जणाई देलु कि आंबे आम वाजी वारस उत्तराधिकारी माने उपर लिखित पथसत्व ग्रहिता से वाजी वारस उत्तराधिकारी मानकु एही पथसत्व बाबदरे कोनोसी मालिकाना दाबी करि परिबु नाही दाबी कले हेले ओ चिरस्थायी ना दाबी पत्र बळ ता अग्राह्य हेबो एणु अत्र चिरस्थायी पथसत्व ना दाबी पत्र लिखिदेलु कि दरकार बेले कर्म रे आसीबो नाउ लेट्स मी सी द तफसिल दैट इज मोस्ट इंपोर्टेंट कटक शहर यूनिट 28 पैसा थाना चाउलियागंज 5 नंबर जिला कटक सब रजिस्टर खाता नंबर 235 424 नंबर फसड़ा इंग्राजी ए चिन्हित मत इजिमाली पथ सत्व अटे यही सत्व तुम्बे ग्रहिता माने जेपरि भावे पानी लाइन इलेक्ट्रिक लाइन आदि नहीं सही परि भाव सरकारी शिरस्थारे रास्ता किसम सर्वसाधारण रास्ता मुक्त कराई नहीं पारियो electricity line and pani line which can be given to public road that is existed in the western side of the house of the plaintiff. Plaintiff road's house is facing toward the western decimal of land for expansion of that particular drain. So what is to be granted is to be granted with respect to a road, not with respect to where there is no road, grant cannot be given. So what has been given, where the pani line and electric line connection is there, that has been given. That is to be taken into consideration and सरकारी शिरस्तर जाई किसम रे सर्वसाधारण रास्ता मुक्त कराई परिबे. So that has been got to see the map. A scheduled land existed in front of the house of the plaintiff, that is A. Now this particular agreement, let's see the agreement. Here it has not been proved.
Exhibit ହେଇଛି
Exhibit 3.
Exhibit 3 ତ
Exhibit 3.
ହଁ 3 ତ ଆପଣ ଦେଖୁଛି
Yes, I am placing the last page. He is stating that Santosh Kumar Bola, Manorama Mohanty, Chandramani Barik. These are signatory. Other that Ajay Kumar Sahu,
Sanjukta Swain.
Sanjukta Swain is the plaintiff. Ajay Kumar Sahu is the owner. Santosh Kumar Bola is not made a party to the suit. Manorama Mohanty has not made a party to the suit. Chandramani Barik is not made a party to the suit. Nobody has signed this agreement below which there is no debt. Debt is not mentioned. But you may see the every page of that document. There is no debt is mentioned. Now what my learned is placing that 19397 is the agreement. What you may see in the last page left side. Hare Krishna Behera. Below his land, name, there is a debt. Who is he? He is neither the witness to the particular deed. He is not the owner of the land. He is not the boundary tenant. No never has claimed any right over the B schedule land. They have not claimed that B schedule land should be given as passage to us because they are also using the road that is in the western side of that particular land. Eastern side there is no road. So they are not made parties. This particular document is not proved and the plaintiff is also not using B schedule land. Not to see the evidence. I am placing the evidence. That is most important. And again the Ajay Kumar Sahu admitted his signature in the last page, that particular agreement in his examination, cross examination, but he has disputed the signature in the map, that sketch map. He has disputed, I have not signed that particular sketch map. That is there in the evidence. Now let's see the evidence. I am placing the evidence of plaintiff PW1. PW1 the plaintiff and PW2 is the husband of the plaintiff. PW1, let's see. Para 31. Para 31 of PW1.
Cross-examination. Cross-examination.
Yes.
Yes. Yes. I've got it.
Cross-examination, let's see. Para 38, most relevant. The road situated on the west side, is our personal road, but municipality now took over the same. We are using the shared passage to approach the main road. Let's got it.
Yes.
40. I know the defend number 1 purchase 7 decimal chokadu from defend number 2 and obtain ROR bearing khata number of 650 of 2360 exhibit 4. I have not challenged before any authority against the mutation ROR. He has known, knew the cell deed. He has not challenged the cell deed during the instrument should be challenged within the 3 years. He has not challenged. Mutation ROR, he has not challenged. And he has admitted that he knew the execution of the cell deed. Thereafter, Lord Simensi, para 42. I am not the co-owner and co-sharer of defend number 2. I have purchased land under the A schedule land from Ajay Kumar Sahu. I cannot say it's a RSD number. Lord Simensi, then I do not, para 44. I do not know anything about Exhibit 3. Exhibit 3 is the grant, that is the agreement. I do not know anything about Exhibit 3. So exhibit 3 is prepared subsequently while preparing the suit. Because that agreement was not available. In the 94, that suit was disposed of based on the Panchayat Faisalnama. There are certain papers are signed by both the parties. Utilizing that paper, he has created that document which was not admitted by that plaintiff in his cross-examination para 44. I do not know about exhibit 3. And Lordship may see para 44. Exhibit and exhibit 9, 8 and 9. There exists no description regarding the existence of a road. Now, Lordship may see PW2, that cross-examination. Para 29. He is the husband of the plaintiff. Para 29. The kisam of B scheduled land, khata number 235, plot number 426 is a duo facility, cultivable land. The road situated under western side of A scheduled property is used by general public. But you got it? Yes, yes. The said road is connected with the main road. The boundary description of the suit land is as follows: north, south, and east, west. Now, Lordship will see para 30. I have not made Kalandi Patra, Chandramani Barik, Bangshidhar Sahu as party to the suit. I am residing over A scheduled property since 94, and dependent number 1 is residing in our land since 2002. Now, Lordship may see para 31. He has denied the right that particular B scheduled land was not given as road in all the 4 suits. Lordship may see para 31. CS number 491 by 2002 is filed by Udishtra Basa against Ajay Kumar Sahu, that dependent number 2 in present suit. It is the fact that in that suit the right of passage over B scheduled land has not been given to me. CS number 14 of 95 is filed by Raghunath Sahu against Ajay Kumar Sahu. It is a fact that in that suit the right of passage over the eastern side of the suit land has not given to me. CS number 94 of 2003 is filed by Bangshidhar Sahu against Ajay Kumar Sahu. It is a fact that in that suit the right of passage over the suit land has not been given to me. In the judgment dated judgment in TS number 160 of 94, that was filed by the plaintiff, no right has been granted to my favor regarding my right of passage over the eastern side of suit land. That is the husband of the plaintiff. In TS number 429 of 95, my right of passage over the suit land has not been granted. Now 32. It is a fact that I was discharging the drain water as well as the foul water of my house over the B scheduled land. That the drain available on the eastern side of the schedule B is connecting with Mohanadi Vihar to the main drain of Aparnanagar. B schedule land joti ses haba katha, seti rohiche drain. There is no road, public road, that is a drain, and that is connecting Mohanadi Vihar to Aparnanagar. Now, Lord, the width of the drain is 5 to 7 feet, but now municipality acquired 30 feet of area for extension of that drain. Dependent number 1 is using the courtyard of Yudhishthira Vasa in order to reach the main road. Dependent number 1 has also no access to the public road. He is using the courtyard of Yudhishthira Vasa. That is suit number 4. Fourth number suit Yudhishthira Vasa, he has got 50 acres. In his courtyard, through which the dependent number 1 is approaching the main road. In order to the main road, the land which was used by me as a drain was down land, and the kisam was Sarad. The adjacent owner of the scheduled land have not filed any civil suit for declaration of right of passage over the land. Chandramani Barik and Mohendra Lanka, the adjacent owner of scheduled land, are now using the passage exist on the western side of the scheduled land. That is the neighbors. The unregistered agreement was executed by Ajay Sahu in favor of Sanjukta Swai, Chandramani Barik, Manojan Mahanti and Santosh Kumar Bola. Kusuma Manjari Rana has not signed the exhibit number 3. That is defend number 1. No one was witness to the execution of this said document. Now, Lordship may see. Yes, Lordship may see the commissioner report.
Exhibit?
It is exhibit C1. There is a map, the C1 that is marked by the court has sent this survey knowing commissioner to this spot. Appellate court has sent. Also got it? No. I have to check that.
The appellate court has taken note of that report. Learned lower appellate court, first appellate court has taken note of that.
It must be there in the record. I am unable to find out immediately, but it must be there.
Let's see. I have
another question. Actually, there's no space here.
Let's see this.
Because of this system, there's no space to go through.
Let's see the certificate copy. This is it.
Oh.
Let's see the map.
Yes.
Respondent is the plaintiff. Here in the appellate court, his land is respondent A ର ଜମି. Schedule A ତାଙ୍କର ଜମିଟାର sketch map ହେଇଛି, that is brown color. Road is at A. Exhibit 3 market is रास्ता. A टाला रास्ता. Schedule B टा जमी of the appellant. Appellant को जमी एवं विवादीय जमी B. There is no road. Road is only in the western side of the land of that respondent. Plaintiff is the respondent, that is the.
Yes.
Lordship has got it. Now, Lordship may see the evidence of. Ajay Kumar Sahu is the owner of the land.
Yes.
I am placing DW3. I am placing para 5. That Ananta Sahu land is not a road, as there is neither such road in the locality, nor I have given consent in written or oral to anybody to use the same as road. Also in the revenue map, there is no such road has been drawn. In area 7.6 kodi from plot number 424, which I have sold to Kusuma Manjari Rana, is not a road, and I have not allotted or gave possession of the said land area of 7.6 kodi to anyone of the locality to use as road. The main drain of Mahanadi is adjacent towards the eastern side of the aforesaid area of 7.6 kodi, so the said area is not connected with any road. That the plaintiff Sanjukta Swai has constructed her boundary wall in respect of her aforesaid plot, but recently she has opened a gate forcibly towards the eastern side of her plot and also disposed of her dirty waters to the plot of the Kusuma Manjari Rana, and for that the reason disturbances has created between them. that the Sanjukta Sai and her family members has been using the adjacent western side municipality road to ingress and egress to their plot since the date of possession, which is connected to the main road, but Kusumandi Rana has no personal road to ingress and egress to her plot. So she and her family members are using the adjacent neighbors' eastern side Bari land as a road to ingress and egress to their plot. Now, Lordship, may see the cross examination. Para 24.
Yes.
Exhibit 3 was confronted to the witness. Second line. In which he admitted his signature appearing on the last page of the document. One sketch map is also attached with the exhibit 3, but on confronting the said sketch map, the witness could not recognize his signature on it.
Got it. That is all?
Lordship?
That is all or anything else?
Let me see the WS. That the suit is hopelessly barred by law of limitation. That is para 3.
Limitation, the court can take up.
At any time, that is a law can be placed at any time. Yes.
So I will just keep it to next week. The map is here actually. If you, unless you are disputing this map.
He has not disputed in the report.
This is that civil court commissioners. Civil court commissioners map would depict the prevalent situation.
Then you file that map only for the purpose of map.
Fine.
And maybe 5 minutes for reply.
I'll reply 5 minutes. I'll just summarize my reply on the next date. But what my humble submission is, with due respect to my learned senior, I learn from him on a daily basis. So it's the submissions that my learned senior advanced. Is like he has filed a cross objection to the judgment.
That I will consider.
Because law of limitation he raised.
Because certain facts are involved. That is why I allowed both of you this latitude to even argue on facts.
Yes.
Because it's very difficult to understand.
Opinions.
No, I know. That I know. But it will be very, very difficult to understand. And for a judge who doesn't carry brief to his home, I open my brief here. So naturally, I have to understand the facts. All right.
Placing one judgment of the Supreme Court.
Heard in part, heard further arguments in part. List this matter next week at the top of the list. Huh? Top of the list, man. Next week, jo weekly list ho. Week commencing soon. So, go to them, na? Are week 13th May at the top of the list. Amar khud na shiva. 9 tarikh shiva to. Ha, 9 tarikh shiva. Will come on
next week. Basic distance.
9th at the top of the list.
Yes.
I have understood the matter. So only
all these certain points which were raised before the learned lower appellate court, he has considered past the judgment. So, but in my humble submission, those findings of the learned appellate court has to be countenanced, not beyond that. So he has in fact gone beyond that. Say he might have raised all these points, but the scope of the points considered has come through in the judgment, which he may need to address, Your Lordship. But going into law of limitation, that was considered and the finding has been rendered.
I'll consider. All right.
And the fact that there is no road, there is no dispute. There is no road. A portion of the property is being used as a road. There's a difference, Lord. I'll clarify all that next.
Better focus your arguments, encapsulate your arguments to be completed within 5 minutes. Or maybe 7 minutes.
It will grant me 15 minutes.
15 minutes?
15 minutes.
No.
Well,
I've granted you enough
it will be a
time.
pleasure to argue 15 more minutes.
It should be the pleasure should be on this side.
That's, I really hope it's.
No, that's all right. Both of you are sufficiently well versed. You are all teaching me civil law.
No,
I'm very poor in civil law.
We are also poor.
Everybody is poor. Before becoming a district judge, I had not even taken up maybe one case, one suit. Otherwise, I had absolutely, or one or two matters. Fortunately, one of the matters has been reported also. Justice L. Mahapatra. Very difficult. Order 21, Rule 99. There was no judgment in this court. Other side was Mr. A.R. Das. And the court requested your senior, Mr. S.P. Mishra, to assist the court on one side and Mr. R.K. Mahanti on the other side.
But in fact, I remember when
That's a reported judgment.
Because when your lordship was the learned district judge, there was a judgment which came to our chambers to assail. So there I've heard my learned senior, I was way too junior back then. But he said that since it has been passed by you, it will require some efforts to, draft the grounds and substantial question of law.
That happens. So that is what is said. But I had absolutely no idea. Before becoming a district judge, that I was dealing with other matters, industrial matters. So naturally. Anyway, it's always a chance to learn. Item kete?
Item 15.
Item 17th May. We commencing 17th May. Kete ko mosera kes?
53. Transport
supplementary. Oh, TRP matter. What?
Is there an interim order? No, in one case interim order there, in another case interim order. There is TRPC and TRP-CRL. TRP-CRL, there is no interim order. TRPC, there is interim.
Is an interim order required?
Yes.
You 15, right? If any application for adjournment is moved on behalf of the petitioner in the court below, the same shall be considered having regard to the date fixed for hearing of